Deputy Madison is getting the last juror who was running a little late, but I guess you all can probably notice the smell in here. So we may have to be delayed a few minutes so we can figure out what that is. I know that there's some issues with the jury room next door, and that may account for some of the smell, but this is different. So if you'll just be patient with us, and I'll have Deputy Madison update everybody as soon as we hear from facilities.
good insurance claim.
So we got the all clear from Decatur Fire. So is there anything else we need to address before we bring in the jury?
Your Honor, I did send the court and the defense an email last night regarding sort of a substitution that we have. Dr. Cunningham, who was supposed to fly in early this morning, contracted COVID, and we consulted with her supervisor and confirmed that she is in fact ill. She is not able to come in, likely until next week. So what we have done is spoken to Dr. Bruce Wayner with the DeKalb County Medical Examiner's Office. We actually met with him last week. He has been reviewing the entire file in this case and has performed a peer review of Dr. Cunningham's work. We would ask him to, we plan on calling him to testify as to his findings based on Dr. Cunningham's report, photos, the evidence, and so on and so forth. Your Honor, we also plan on calling the medical examiner's office investigator, who's also the custodian of records there. His name is Jess Dillard, simply for the purpose of admitting the photographs and other records from the case, as well as investigator Amber Winslow, who responded to the crime scene and collected the knife that was removed from Ms. Merritt's face. Yes, I know.
Judge, the state did inform us yesterday. It actually came up previously, as the court's well aware. The state did inform us on yesterday.
Well, no, court's not well aware of it. I know that there were some issues with getting the doctor flown in. And I don't see an email, so maybe, I don't know if it was maybe sent to the wrong address.
I sent it to Ms. Campbell.
Okay. Okay. I know we're in the home stretch now, but if I would prefer that you also send it to me so that I can review it as well.
Would you like me to send it to you now?
Sure. Go ahead, Mr. Queen. Sorry.
No, so Judge, like weeks ago, there was concern with Dr. Cunningham, and the state reached out to me then and obviously gave my position. We talked about Zoom, et cetera, et cetera. And we expressed our position to the state. The state did go through efforts.
You expressed your what? Did you say opposition?
At the time, yes.
Okay.
But yesterday, the state did reach out to our office. The state did provide some case law. We did review the case law. So at this time, I will say that on a preliminary basis, we believe that the law may support having another medical examiner come in and testify under Georgia law. There are certain foundational steps which need to be completed before that testimony comes in. It is our understanding that the state intends to call multiple witnesses in order to satisfy those foundational steps. So, as it stands right now, Your Honor, we are not objecting to this idea that someone else may be testifying on behalf of Dr. Cunningham. There are, like I said, foundational steps the state must complete. If the state fails to complete those, then obviously we will be rejecting in the appropriate time.
Okay. Would you, if you haven't already, Ms. Pott, go ahead and share those cases? I'm familiar with the case law, but I just want to make sure that we're all on the same page.
Yes.
That you shared with the defense.
Yes, and they were in the email that I sent. I just forwarded it to Your Honor.
Okay.
But I wanted to, the first, let's see, I don't know if these are in order.
No. Let me ask this first. Mr. Queen, now that we know what witnesses are going to testify, did you need any additional time to speak to the witnesses before they're called?
Well, unfortunately, Judge, thanks to the little time break we had, we did have an opportunity to speak to those witnesses.
Okay, good.
So we do not need any time to speak to the witnesses. The cases which are, I believe, in Ms. Pott's hand are the ones which were forwarded to us. We did review those. We also reviewed some other cases inside and outside of Georgia. So if she was put on the record, that's fine, Judge. We are well aware of the case law issue.
Okay.
Would you like me to put those on the record, Your Honor?
Yes, please.
Okay. The first is Clark versus State. It's a Georgia Supreme Court case, 296, Georgia 543. It's a 2015 case. In that case, the Supreme Court held that it was not error to allow a medical examiner who was not present during an autopsy to give an opinion as to the victim's cause of death. Naji versus State, that's spelled N-A-J-I. Again, it's a Supreme Court of Georgia case. 300, Georgia 659. It's a 2017 opinion. In that case, the court held that the testimony of a medical examiner who did not perform the autopsy did not violate the Confrontation Clause. And in Stewart versus State, that's a Court of Appeals case. Citation is 356, Georgia at 364. It's a 2020 case. This case does not involve a medical examiner, but it does deal with expert witnesses. And in that case, the Court of Appeals held that the trial court did not err by allowing a forensic biologist who did not conduct a former co-worker's analysis of a DNA sample to testify of her peer review of the former co-worker's findings. And do you need copies, Mr. Queen?
I do not, thank you.
Your Honor, I do have some copies that I can present to the court or the court reporter. Would you like these?
Yes, if you give them Ms. Campbell. Okay. All right, so seems like we're all on the same page at this point. Is there anything else?
Not from the state, Your Honor.
Mr. Queen?
No, Your Honor.
Okay. All right, you can bring your...
What was that? Open the PowerPoint first.
You all may be seated. Good morning, ladies and gentlemen. I hope that you all had an enjoyable extended weekend. I want to apologize for the delay. When we were about to get started this morning, we started to smell something that smelled like it was electrical, something burning in the courtroom. So we wanted to make sure before we brought you out, we did contact the Decatur Fire Department that came, used their equipment to see if there were any hot spots anywhere. They didn't find anything, and they gave us the all clear. So that's why we've been delayed this morning. So I apologize for the inconvenience, but thank you for your patience. All right, we're ready to continue on with testimony. The state will call us next witness.
The the state called investigator Jess Dillard.
Yes, sir. So you may be seated. Raise your hand, please. You swear to affirm the testimony that they will be the truth, the whole truth, and nothing but the truth, sir? I do.
Good morning, Investigator Dillard. Would you please state your name and occupation for the jury?
Jess Dillard. I'm a senior investigator with the DeKalb County Medical Examiner's Office.
Okay. What does the medical examiner's office do?
Basically, we establish the cause and manner of death on any suspicious or violent deaths.
And how is that done? Can you just give a general description of the process?
Absolutely. Generally, it starts with our notification, either from the police department or hospitals, anybody else in authority that's involved. They'll notify us. Basically, they'll notify the investigators. We will go out to the scene and gather the information that our forensic pathologists will need to assist them in establishing a cause and manner of death.
Okay. Would you pull the microphone closer to your face just a little bit? All right. And are records kept during the course of the investigation and autopsy?
Yes.
All right. And are those records kept in the ordinary course of business?
That's correct. Yes.
Okay. Are you the custodian of records for the medical examiner's office?
I am.
And are records kept for each autopsy and investigation that's performed?
Yes, they are.
How are they kept?
They're in a digital case file. It's a program called Medical Legal Death Investigation.
Right. And are they labeled in any way?
They are.
And how so?
So when the case is first created, labels are made on a printer, little stickers. So anything that comes in that may be evidence or any photographs that we take, we attach that label to the photograph.
And does each case have a unique number?
That's correct, yes.
Okay, I think you just said that. I apologize. I'm just clarifying. Did the medical examiner's office perform any investigation with regard to the death of Shirley Merritt?
Yes.
And was an autopsy performed?
Yes.
Was a case number given to that case?
Yes.
All right. Do you recall what that was?
Not offhand. I've got tens of thousands of cases running through my head, so the specific number is not coming to me.
Would it refresh your recollection if I were to show you a photograph from that autopsy? You could just tell the jury what the case number was that was given by the medical examiner's office in this case.
So the case number was 19-0188. The 19 reflects the year 2019, and 0188 reflects the number that was called, or that's the death report number. We had 188 cases. This was the 188th one.
And have you had the chance to review the records that were kept under that case number prior to coming to court today?
As far as reviewing, I just made sure they were there.
All right. I'm going to show you what have been marked as state's exhibits, and these are a little bit out of order, but 59, 61, 62, 63, 65, 66, 64, 67, and 68. Would you look at these and tell me if these actually are photographs that were kept in that case file in the ordinary course of business?
Yes, so reviewing these photographs, they're all labeled with the appropriate case number and information reflecting this specific case.
Were these photographs that were taken during the autopsy of Shirley Merritt on February 3rd of 2019?
I believe they are. They also include the date. The exam was February 4th, 2019.
And who performed the exam?
Dr. Cunningham?
Was Dr. Cunningham an employee with the medical examiner's office?
She was.
Where is she now?
I believe she's in Arkansas.
And was she able to come to court today?
I have no idea.
Your Honor, at this time I move to admit the exhibits that previously listed. I apologize. Again, these are out of order. 61, 68, 67, 64, 66, 65, 63, 62, and 59.
Did you include 64 or 69?
Yes, both of those.
69.
I'm sorry,
Not
I said
69.
59.
Okay.
59. And yes, 64 is one of those photographs. 69, I misspoke. It's 59.
Okay. Great. Any objection?
No objection.
Admitted.
No further questions.
Good morning. Just briefly, you did not take the photographs that have been entered, correct?
I did not.
You were just the record keeper?
Correct.
And had you viewed these photographs prior to today?
I did.
And was that earlier last week?
Yes.
That's all my questions. Thank you.
Any redirect?
No, Your Honor.
Any witness to excuse?
Yes.
Ms. Wolfgerber?
Yes.
All right. Thank you, investigator. Call your next witness.
The state calls Dr. Bruce Weiner.
Good morning, Your Honor. I do. State my name?
Yes, please.
My name is Dr. Bruce Weiner, W-A-I-N-E-R.
How are you employed?
I'm a associate medical examiner at the DeKalb County Medical Examiner's Office.
All right. What does a medical examiner do?
A medical examiner investigates deaths in which the manner of death has not been determined, and also the possibility of either accidents, homicides, suicides, and we also investigate sudden unexplained infant deaths.
What kind of training and experience do you have that qualifies you to be a medical examiner?
A medical examiner has to have a medical degree, having gone to medical school, and then having gone through a residency in anatomic pathology, and then undergone a specific fellowship in forensic pathology.
And where are your degrees from, and what are those degrees?
I have a MD and PhD degree from the University of Chicago.
And in what?
Pardon?
In what? What are your degrees in?
Medicine, MD, medical doctor, and PhD, Doctor of Philosophy in experimental pathology, which was actually immunology in those days.
And where was your residency?
My residency was at the University of Chicago Hospital and Clinics.
How long have you been employed as a medical examiner?
I have been working as a forensic pathologist since 2010, and I have been working at the DeKalb County Medical Examiner's Office since August of 2022.
And have you? I understand that you've worked you've taught before as well. Is that correct?
I
Worked for various universities.
Yes.
And can you explain to the jury those positions?
Yes. After I completed my residency at the University of Chicago, I was invited to join the faculty, and I rose to the rank of full professor with tenure. Subsequent to that, I was chairman of the pathology department at the Albert Einstein College of Medicine in Bronx, New York. And following that, I had an endowed professorship at Emory University School of Medicine.
How many autopsies do you think you've performed in the course of your career?
It would be hard to count, but it would have been probably maybe in the high hundreds.
And have you testified as an expert in the field of forensic pathology in the past?
Yes, I have.
Can you say how many times?
I would say multiple times, probably close to 50 or more.
Your Honor, at this time I'd move to tender Dr. Weiner as an expert in forensic pathology.
Any objection? No. He will be so recognized.
Dr. Weiner, if you could just briefly explain to the jury what an autopsy is.
Yes. An autopsy is a post-mortem examination of a body. Post-mortem meaning after death. And there are two components. The first component is what's called the external examination, where we document the normal external features of the decedent, and we also document any injuries that may be present. These this documentation is placed on diagrams. I usually use a diagram for the normal features of the individual and another diagram to document any injuries that may be identified. The second part is the internal examination, where we remove the internal organs, weigh them, examine them, document their weights and features, and obviously if there are any abnormal features, we document that. And in cases where we need to perform a more detailed examination or on any organ, we will take a sample of tissue and submit it for microscopic analysis. At the time of the autopsy, we also collect blood to be sent out for toxicological analysis. And routinely we will do, at least in some cases, urine screens for the presence of drug. And in some cases we'll take fluid from the eye, that's called vitreous fluid, and send that for analysis of electrolytes.
Did you perform the autopsy on the body of Shirley Merritt on February 4th of 2019?
No, I did not.
Who did?
Dr. Christy Cunningham.
All right. Is Dr. Cunningham currently employed as a medical examiner with the DeKalb County ME's office?
No, she is not.
Okay. Do you know if she's currently employed as a medical examiner?
My understanding is that she is employed as a medical examiner in the state of Arkansas.
Is it common when you are working as a medical examiner in a medical examiner's office that you review autopsies performed by other doctors?
Yes.
Okay, and is it common in your practice to testify as to your opinion regarding an autopsy that you did not perform?
Yes.
And in doing so, what records do you review?
What reference?
Records. Do you
Records,
review?
excuse me. I review the report itself. I will review any additional studies that were performed, for example, perhaps toxicology. And I will review all of the records, all of the photographs that were taken, both at the scene of the death and also during the autopsy.
Did you, in fact, review the records that were taken and the reports written regarding the autopsy on Shirley Merritt?
Yes, I did.
And did you have the opportunity of making your own observations and conclusions with regard to the injuries found on Miss Merritt's body?
Yes, I did.
All right. I want to discuss those injuries with you. Was an anatomical sketch prepared by Dr. Cunningham in the course of her performing that autopsy?
Yes.
Okay. And is that an item that you reviewed?
Yes.
I'm going to show you State's Exhibit 58. If you could just have a look at that. And
Yes.
would it assist you in explaining the injuries in your findings if you were to be able to look at and show the jury a copy of that anatomical drawing?
Yes.
Okay. Your Honor, at this time, I would move to admit State's Exhibit 58 and 58A, which is just a larger copy of that, for demonstrative purposes only.
Any objection? Admitted.
Barely.
All right. And Dr. Weiner, you actually have a copy of that exhibit. If you would like to, I left it on the witness stand. If you would like to have a look at that while you're testifying.
If I may, are you going to ask me to explain the various injuries?
I'll point out certain injuries and
Okay,
we'll
I'm
discuss
sorry.
them. Were there injuries to Mrs. Merritt's back, as we see here on 58A?
Yes.
Okay. And can you describe what those injuries appear to be based on your review of the case?
Yes, they are stab wounds.
I'm going to show the jury State's Exhibit 65, Your Honor. I don't think it's on display.
There.
Oh, there we go. Okay, thank you. Is this photograph a photo of those injuries that I just pointed out?
Yes.
And that you said that they appear to be stab wounds. Is that correct?
Yes.
What do you mean by a stab wound?
A stab wound is a result of what we call a sharp force injury. A sharp object, a knife, for example, it enters the skin, and the definition of a stab wound is that the depth of the knife wound is greater than the length of the surface wound. If the surface wound is superficial, if the knife doesn't penetrate very far, then we call that an incised wound. For example, like a running the knife blade over the surface of the skin, but not entering at any great distance.
Looking at State's Exhibit 61, which has previously been admitted into evidence, based on your observations, is it your opinion that those stab wounds in the photograph that's being displayed now are consistent with having been made by the weapon in State's Exhibit 61?
Yes.
Okay. And are they consistent with each other in the sense that do they appear to have been made by the same blade?
Yes.
How so?
The configurations are almost identical, and judging from the length of each wound, the length of each wound is very similar, and it's consistent with the width of the blade.
Are you able to see the photograph on the screen in front
I
of you?
have so many photographs in front of me, it's hard to keep track.
Okay. I just wanted to make sure that
Yes.
you're seeing what we're seeing. Looking at State's Exhibit 66, where on the body is this wound or injury located?
I believe that's on the torso.
Okay. Do you know which area of the torso?
I think that's on the right.
Okay. And is this wound also consistent with being made by, well, how would you describe this wound?
This is a more complex wound where it appears that they can't see my pointer, can they?
No, but you can stand up.
Oh, thank you.
Or I think that would probably be, well, you know what, I don't know if they can see behind
It
the,
looks like the edge of the knife either entered here but then was turned so that it pivoted on the initial entrance site or the initial axis.
does that indicate to you?
I can say twisted instead of turned. That's what I meant.
Does that indicate movement by one of the parties to you?
Excuse me?
Does that indicate movement to you by one of the parties?
Well, it could be movement by the blade or it could be movement by the decedent.
And would you consider this to be a stab wound as well?
Yes.
I next want to focus on the injuries, specifically the injury that's marked stab wound on the decedent's neck.
Yes.
On State's Exhibit 64, we see two wounds. How would you describe those?
They both appear to be stab wounds.
And based on your observations, are they consistent with having been made by the knife that you can see in State's Exhibit 61 in front of you?
Yes.
Okay. Let's talk about each of those stab wounds. And I want to talk about the one that's kind of lower down on the left clavicle. Based on your review of this case, do you believe that this injury would have been life-threatening?
It could have been life-threatening, yes.
Okay. Do you believe that it was something that immediately would have incapacitated the decedent?
Not necessarily.
Okay. Now, what about the wound on the right side of the neck that we see above it? Can you describe what we're looking at in that wound, on the neck?
That particular wound entered the soft tissue of the neck, and it cut the external jugular vein.
What does the jugular vein do?
It returns blood from the head to the heart.
Was that a life-threatening injury?
Yes, that could be life-threatening.
Okay. How would a person die from that kind of injury?
They would die from excessive loss of blood. The technical term that we use is hypovolemic shock.
Would that wound have immediately ended the life of Shirley Merritt?
Not immediately.
Okay. How long do you expect Miss Merritt would have lived after receiving that stab wound to the neck?
She could survive on the order of minutes.
I'm sorry, what was that? The order?
On the order of minutes.
Minutes, and can you say 10 minutes versus 2 minutes? Do you know?
I would say maybe 2 to 3 minutes or 2 to 5 minutes.
Would it immediately have incapacitated Miss Merritt?
Not immediately.
Would Miss Merritt have been able to move during those minutes after receiving that injury to the neck?
Yes.
Would she have been able to speak or make any vocal sounds?
She should have been able to speak or make vocal sounds.
I want to discuss some of the other injuries that we see on this anatomy chart. First of all, it's labeled stab wound to the face. Is that an injury that you would, and I'll show you State's Exhibit 59 for your review. Do you see that stab wound that's labeled as stab wound to the face here in that photograph?
Yes.
Would you consider that injury to be immediately life-threatening?
Not necessarily.
Would that be an injury that would immediately incapacitate Ms. Merritt?
It could incapacitate her, yes.
But would it have done so immediately?
No, not necessarily.
And finally, I want to focus on what is marked here. It appears to be the right side of the head.
The right side of the head?
Yes.
Okay, I understand, yes.
If you see that?
Yes.
If we're looking from the back, it's the right
Yes.
side of the head. Would you please look at State's Exhibit 62? What does that exhibit show?
What that exhibit shows is a gaping laceration on the side of the head. Laceration meaning a tear in the tissue that looks like a combination of both what we call blunt impact injury, but with an object that has an edge capable of tearing the skin surface and opening it up as a laceration.
Just a moment.
Also, in the center of that picture is a elliptical opening that's consistent with the blade of a knife, the tip of a knife, reaching that depth, most likely from the facial stab wound on that side.
Would that injury to the right side of the head, would that have been immediately life-threatening?
Yes.
And would it have caused would it immediately have incapacitated Mrs. Merritt?
Yes.
Okay. And is that consistent with being caused by a heavy object?
Yes.
In your opinion, what was the cause of death of Mrs. Merritt?
The cause of death was a combination of blunt impact injury and stab wounds.
Okay. And how did the blunt impact injury to the head cause death?
The blunt impact injury seen in that picture actually fractured the underlying skull. It also produced a fracture of the part of the skull that is underneath the brain. We call that the basilar portion of the skull, and we call that a basilar skull fracture. It caused hemorrhages over the surface of the brain that we call subarachnoid hemorrhages, and it also caused hemorrhages within the brain, which we call contusions or bruises within the brain. The combination of those types of injuries would have produced irreversible brain damage. I say that not only as a forensic pathologist, but I'm also a neuropathologist.
Dr. Weiner, would that injury to the right side of the head have been consistent with being caused by the 35-pound dumbbell as we see in State's Exhibit 32?
Yes.
When we watch movies or shows like CSI sometimes, you hear a medical examiner or an investigator who finds a body and is able to put a time of death on that body. Is that something that happens in real life?
Not really.
Okay. What are some of the factors that you need to consider when determining whether you are able to determine a time of death?
We usually start with the time when the decedent is pronounced. We look at the presence of several factors. One is rigor, which means that the muscles begin to contract a short time after death, whether there's rigor present or whether it is past. And also another observation in terms of that we call lividity, which is the pooling of blood where the body has been laying. Usually the pooling occurs in a dependent position. So if the body's laying on the back, the blood will pool on the back. If we apply pressure to this area of lividity, if it blanches, it becomes pale, it hasn't been fixed. So that means that the death interval, has been relatively short. If it doesn't blanch, we say that the lividity is fixed, and that indicates that the body has been deceased somewhat longer. There are a number of environmental factors that we have to consider. So considering the time of death is not a precise science.
you did discuss rigor. When does rigor generally set in? Can you approximate that after the death?
It'll usually begin to set in within maybe 30 minutes to an hour.
And how long does rigor last?
Again, depending on environmental circumstances, rigor can last for up to 48, even in some cases 72 hours.
When a body is collected by the medical examiner's office, is it refrigerated somehow?
Yes.
And how does that affect rigor?
That can, in some ways, it can enhance rigor,
All right.
but not always.
All right. And do you know whether Shirley Merritt was in that state of rigor at the time that she was examined by Dr. Cunningham?
Yes, it's stated in the report.
Okay. And are you able to put any kind of precise timing on her death?
No, I can't put a precise timing.
Can you estimate?
One could estimate, based on when she was last seen alive.
Okay. Based on your review of this case, would it be possible or would it be consistent with your findings that Miss Merritt died sometime during the day of February 1st of 2019?
Yes, that would be consistent with the findings at autopsy.
I have no further questions.
Good morning, doctor.
Good morning.
You are not the medical examiner who examined the body of Miss Merritt, correct?
Correct.
You never came in contact with the deceased in this case?
No, I did not.
You did not go to 1590 Planters Row?
No,
And you didn't visit the scene of this case?
I did not.
Your involvement did not begin until recently, correct?
Correct.
And that was when?
I believe it was last week.
Now, the state just asked you about time of death, and you indicated that that is a difficult thing to give, correct?
In some instances, yes.
And there was no actual time of death given in this case, right?
Correct.
And in reviewing the reports and the photographs, you cannot say whether it was just one single stab wound or one of the blunt force injuries that caused this death.
Could you rephrase the question?
Sure. The determination in this case was that it was a combination of wounds that caused the death. Is that right?
Yes.
In other words, it was not just one single injury.
Yes.
And you cannot say in this case the number of assailants involved in the death.
No, I cannot.
Nothing further. Thank you, doctor.
Dr. Weiner, may I continue, Your Honor?
Yeah.
Dr. Weiner, would the injury to Miss Merritt's neck that we see in State's Exhibit #64 in State's Exhibit 64, would this injury alone have caused Mrs. Merritt to die?
Potentially, yes.
And what about the injury to the right side of her head, which you described as a blunt impact injury? Would that have alone caused Mrs. Merritt to die?
Yes.
Okay. And I just had one other thing. There, if you look at Exhibit 58 and 58A, there appears to be on the front of Miss Merritt's face some kind of bruise or contusion, and you can see it in the photographs.
Yes.
Can you give a description to the jury of what you believe that injury kind of around Mrs. Merritt's eye to be?
There's an abrasion present, and it's on a bruised base. We will frequently describe an injury like that as a abrasion over a contusion.
Okay. And what would that have been caused by?
Blunt impact trauma.
And are each of the incised and stab wounds that you have reviewed in the photographs, do they appear, is it consistent that they would have all been caused by the same weapon?
Yes.
And would the weapon, as you see in State's Exhibit 61, is that consistent with potentially having caused each of those injuries?
Yes, it is.
Okay. No further questions.
Anything further, this witness?
Not from the State, Your Honor.
May the witness be excused.
Yes, Your Honor. Yes.
All right. Thank you, Dr. Weiner.
Thank you, Your Honor.
All right, next witness.
The State calls Investigator Amber Winslow.
Amber Winslow, AMBER WINSLOW.
Good morning, Investigator Winslow. How are you employed?
I am Deputy Chief Investigator at the DeKalb County Medical Examiner's Office.
How long have you been employed with the ME's office?
6 years.
All right. And what does an investigator with the ME's office do?
We document and investigate all reported deaths to our office, deaths that occur in DeKalb County.
Do you go to the scene where a death has occurred?
Depending on the type of death, yes.
Okay. When there is a suspected homicide, do you respond to those scenes?
We do if the decedent is still on scene, yes.
Okay. Do you recall responding to Planters Way in Stone Mountain on February 1st of 2019?
I believe on February 2nd, I did respond.
I apologize. February 2nd. What was the call in regard to?
It was in regards to a homicide.
Okay. Was the decedent still on the scene at that time?
Yes.
Do you recall what time you responded to that scene?
I responded at 2:15
It was at 2:15 a.m. or p.m.?
p.m. I'm sorry.
All right. And what did you find when you responded?
Well, our response, we come, after the police were the last ones to arrive. So I meet with detectives, get whatever information I need. I photograph the scene, immediate scene, and the body that is on scene. So on this particular day, I did all of that, and I was escorted into the scene, and that's where Miss Merritt, to her body, and she was at the bottom of the stairs, the basement.
All right. And can you just give a general description of her body when you responded to the scene?
Yes. She was at the bottom of the stairs, lying on her left side, kind of in a curled up position. She was fully clothed. When I say that, that's something we document, Upon further investigation, we have to document any injury, trauma, anything like that, and photograph it as well.
And did you turn her over at any time?
Yes, absolutely. So we photograph and document what we see initially, and then I did flip her over to see if there were any other injury or trauma to her, to the other side of her body.
Did you see any injuries when you turned her over that you did not see initially when you responded?
I did.
Can you describe that for the jury?
Yes. When I flipped her over, I did observe what appeared to be sharp force injuries to her neck area, and also trauma to her face, and also I observed a very large knife blade sticking out of her cheek, her right cheek.
Did you see any items around Mrs. Merritt's body that you recall?
Yes. Crime scene for the police department had already been there, so they had items marked. I did observe one of the pieces of evidence marked was a black knife, a handle to a knife, and also a weight, a 35-pound weight was also marked.
Investigator Winslow, can I get you to move a little closer or speak up just a little bit?
Yes, Your Honor.
Okay,
Sorry.
Do you have experience with determining whether a body is in rigor mortis?
I do have some experience, yes.
And could you tell, just based on your observation, whether Mrs. Merritt's body was in rigor at that time?
Once I did manipulate her body and roll her over, I did observe her to be in rigor, yes.
And what information are you basing that on?
Her muscles were stiff, so when I rolled her, her body stayed in that position with her knees bent. Her arms remained in the position they were when she was initially found. So when I rolled her up, her muscles in her hands and arms were stiff and staying in that position. They didn't just fall limp once I moved her.
Did you notice anything in Mrs. Merritt's hands?
I did. I did observe she had hair. It appeared to be possibly her own hair.
I'm going to show you State's Exhibit 67. Is this a photograph of one of Mrs. Merritt's hands?
It is. It is.
And what are we looking at here in State's Exhibit 68?
Right. That's her right hand, and that has hair in it. It appears to be the way she was found. Her hand was up near her face and head, so it appears to me that was her hair. So,
did you bag her hands?
Absolutely. On every homicide, we bag their hands, whether we see any type of evidence or not. Just something we do in case there's trace evidence that we can't see, but we do that to protect any evidence so then it can be recovered back at the lab during the autopsy.
And that evidence that you were protecting, would that have been the hair in Mrs. Merritt's hand?
Correct.
I'm going to show you, I'll show you what I've marked as State's Exhibit 60. would you please look at that item and explain what it is to the jury?
Okay. This is an, am I allowed to open it?
Yes.
Okay. An evidence box that came from our lab. Sorry. This is the blade to, this is the knife blade that was found sticking out of her face. This blade, I don't remove anything from scenes, so I photographed it, left it in place for the doctor to see. Okay, prepared her for transport by placing her in a body bag with that still in her face, and sealed the bag with a tag and a zip tie. From there, she was transported from the scene to the lab, where they would have removed that during autopsy.
Would you, how were you able to identify this as the actual blade that was removed from Mrs. Merritt's face?
It was mainly because this is our evidence box, this is our label that has our case number, the victim's information, and anyone from our office that is involved in the case, the doctor's name, the lab tech, and my name as the investigator.
And what is the case number that's labeled with?
19-0188.
This time I'd move to admit State's Exhibit 60.
Any objections?
No objection.
Admitted.
Did you photograph that item as well?
I did.
Looking at State's Exhibit 61. Was that blade longer than 3 inches in length?
Yes, it appears to be. I did not measure it personally because, again, at scene, we don't manipulate anything like that. But yes.
Was it consistent with being a kitchen knife?
It appears so. It appeared to be, yes.
Thank you, investigator.
Good morning, Investigator Winslow. When you arrived at the scene, I believe you said it was 2:18 p.m., you met with the officers that were already there, is that right?
Yes, you have at 2:15.
And they...
I'm sorry? Oh, I'm sorry. I said I think it was 2:15, my response time.
And they inform you about the scene that you're going to go into, is that right?
Right. They give me any additional information and their investigation that's ongoing at the time, but yes.
And at that time, they informed you about the suspect, Richard Merritt, is that right?
Yes.
And that was the only person that they informed you about as a suspect at that time,
At
right?
that time, that is correct.
Thank you. Nothing further, thank you.
Anything further?
No, Your Honor.
May the witness be excused.
Yes.
Ms. Wolf-Gruber?
Yes.
All right. Thank you, Investigator Winslow. Call your next witness.
Your Honor, this time the state rests.
All right, ladies and gentlemen, I'm going to ask you all to please step into the jury room for a moment. Are there any motions for the court to consider?
Not from the state.
Your Honor, this time we're going to move for the verdict of acquittal. The state has done an admirable job of proving that Mrs. Merritt was the victim of a homicide. However, we believe that that they have fallen short of proving that Richard Merritt is the perpetrator in this case. So we therefore move for acquittal as to all counts.
Ms. Pott?
Your Honor, I believe that we have identified the defendant as the perpetrator. He was at the house between 9:38 a.m. and 2:30 that day. After he left, there were no signs of forced entry, no signs of any tampering or any theft other than the vehicle and the phone that he had stolen from his mother. The victim was cooking a meal for the defendant before he was supposed to turn himself into jail. And as she explained to her husband's cousin, Mike Jeffcoat, things were bad that day. He absconded from the scene, and Your Honor, the only reasonable theory of what happened during that day was that the defendant committed this offense. Yes, and additionally, Your Honor, the victim, Mrs. Merritt, was killed by items from inside the home.
All right, the court does find that there is sufficient evidence that has been submitted for this case to go forward to the jury, and I find that as to all 6 counts in the indictment, so I will deny the defendant's motion. Mr. Queen, has your client made a decision about whether or not he's going to testify?
Your Honor, can I speak to Mr. Merritt briefly on that matter?
Yes.
In the back.
Yes. Be in recess for about 10 minutes. Deputy Madison, once you've taken him in the back, will you let the jury know we're going to take a short break and then we'll come back for testimony before lunch? Mr. Queen, has your client made a decision about whether or not he's going to testify?
He has, Your Honor.
All right, Mr. Merritt, if you'll please stand. Mr. Merritt, I'm going to ask you a few questions on the record, and I need to make sure that you keep your voice up so that the court reporter can take down your responses.
Yes, ma'am.
Do you understand that you have a right to testify, and if you want to testify, then no one can prevent you from doing so?
I do.
Do you understand that no one can make or compel you to testify? That is, do you understand that you have a right to not testify if you do not want to? Do you understand that not your lawyer, but you personally are the one who decides whether you will testify or not?
I understand.
Do you understand if you do not testify, then upon proper request by you, the court will instruct the jury that your decision cannot be used against you? Do you understand if you choose to testify, you will both be examined by your counsel and cross-examined by the assistant DA?
I understand.
Do you personally want to testify or not?
I would like to testify.
I find the defendant has decided to testify with a complete understanding of his rights. You'll bring the jury in.
Excuse me, Your Honor.
Yes.
Let's see, two matters. One, I'm not sure, is the court going to put Mr. Merritt on the stand? Because he is on with the leg ankle.
Do you intend to call him first?
Yes.
Okay. Yes.
They can either move him or put him on the stand at a time. I have no preference.
I think we should go ahead and let him be on the stand when the jury comes in.
Second matter, Your Honor. Probably the first business which the state, or excuse me, the defense will be putting forth is defensive number 2, which is a certified copy of the arrest warrant in this case. Magistrate court.
I'm sorry, it's the what? Okay.
The arrest warrant, certified.
Okay.
That's the first matter. And Your Honor, I anticipate during the course of Mr. Merritt's testimony, we will be seeking to present a 4-page document, which is a letter accompanied by some handwritten notes. It's defensive number 3. The letter is a letter which was typed up by Ms. Merritt, Ms. Shirley Merritt, and sent to Mr. Merritt's attorney, Mr. David Willingham. The letter was created 2 days, well, actually 1 day before the sentencing hearing. But 2 days before the sentencing hearing, Ms. Merritt was hospitalized. And I think we had some discussion about that. She was having some chest issues, some heart issues. She was hospitalized. And then the next day when she was released, she created this letter. And this letter talks about some of the issues regarding the case, some of the issues about the conflict and the distress it caused her and the family. And then this letter, which is actually in the discovery, is one of the items which CSI Burnett testified about documents being by the nightstand in Ms. Merritt's room. Mr. Merritt, he has actual direct knowledge of his mother creating this letter, of his mother expressing concerns to the attorney, Mr. David Willingham. And Your Honor, we believe they are admissible under 24-803 as they are present sense impressions when she got out of the hospital and the stress and agony she was going through. We also believe they express her then existing mental, emotional, and physical condition. And then finally, Your Honor, we believe that they do fall within, if not under 24-803, they fall under 24-807, the residual hearsay exception, where there are evidence of material fact. They are more prone to on point, which is often an any other evidence, which the opponent can procure with reasonable efforts. So, Judge, if the state has an issue with it, I think we need to resolve that issue now, prior to Mr. Merritt's testimony.
Can I see the exhibit?
Yes, Your Honor.
So, Mr. Queen, you indicate this is a 4-page exhibit, but it looks like the letter from Mrs. Merritt is only the first 2 pages. And the last 2 pages, in addition to the bottom of the second page, appears to be handwriting. So, is this how the letter was received by the attorney?
The attorney received the first 2 pages. It appears that the document which was left by the bed is actually the 4 pages.
So whose handwriting is this?
That is Mrs. Merritt's handwriting.
And somebody's going to be able to identify that as her handwriting?
Mr. Merritt, yes. Yes, Your Honor.
Hi.
Yes. First, let me address 248807.
Hold on just 1 second. Go ahead.
All right, first, let me just get the residual hearsay exception out of the way. 248807 requires that a proponent offers sufficient notice of their intent to use that item under this hearsay exception. It says that a statement may not be admitted under this code section unless the proponent of it makes known to the adverse party sufficiently in advance of the trial or hearing to provide the adverse party with a fair opportunity to prepare to meet it, the proponent's intention to offer the statement and the particulars of it, including the name and address of the declarant. We have not had any kind of advance notice. This is the first that we've heard that they do intend to use it. We've always considered this to be hearsay of Mrs. Merritt that does not fall under any exception. As to present sense impression, Your Honor, a present sense impression is something like when somebody calls 911 and they're talking about the impressions that they have at the time that they are seeing them. That's not the case in this letter here. She talks about something that happened in the past, and she actually says, I felt nauseated, dizzy, and nearly fainted. Again, that's clear that she is not speaking in the present sense, but rather of what had happened in the past. Additionally, this is full of hearsay. She's talking about what Janine allegedly had said to her in the past, and she's describing events that occurred in the days preceding her writing this letter. Again, there's no guarantees of trustworthiness. There's no, as to the letter, I'm not sure how they intend to admit this and authenticate it, but it's a typewritten letter. Nobody can testify as to whether Mrs. Merritt wrote it, or it was found in the house, but it could have just as easily been written by the defendant, and so there's no way to authenticate it. I know that David Willingham, the defendant's previous attorney in Cobb County, was under subpoena, but I believe he was told not to come this morning by the defense. So I don't think that they'll be able to authenticate this through him either. I just think that there's issues all around with this letter, and I don't think that it falls under any of the hearsay exceptions. So I'd ask that it not be admitted.
Well, the residual exception would only apply if the court doesn't find that it falls underneath one of the other exceptions to hearsay. Mr. Queen, as far as 803 goes, explain to me how this is an excited utterance.
Judge, I'm not saying it's excited. I'm just saying the present sense impression. 803.1.
Okay. How is this a present sense impression then?
Because the statute says that the statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter.
Okay, but the very first line of this is, I'm very upset over the turn of events this week. It doesn't give an indication of the time period within which she is allegedly writing this letter, or when the flyer in the mailbox was received. So how does this indicate that this was prepared while the declarant was still under the stress of the situation?
The letter is dated January 17th.
I understand.
She was hospitalized on the 16th. We already heard from Ms. Metacozy that a couple of days prior to the sentencing, which the record shows on the 18th, is when the cartoon was sent. And Ms. Metacozy testified that she did speak to Ms. Merritt regarding the contents of the cartoon, which puts us the 16th, 17th. And here we have Ms. Merritt describes in the letter here that the cartoon, which prior she believes having concerns and physical palpitations that caused her to be hospitalized on the 16th. And the judge, just to jump back for a moment, as to notice, this is the state's evidence. The state has the originals in their file. So the state...
Well, evidence is evidence. It doesn't necessarily belong to either party. It's evidence in the case, regardless of who has it. So it's not the state's evidence. It's evidence in the case. But again, the exception, the rule says a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. So again, unless someone is going to be able to testify as to when exactly Ms. Merritt received the cartoon related to when she wrote this letter, I don't see how this qualifies under that exception.
Again, Your Honor, Mr. Merritt, he testifies the date which they received the cartoon. They're living in the same house. The date they received the cartoon.
Which would be what date?
I believe that's on the 16th? 14th. The letter was received on the 14th.
Uh-huh.
The mother's hospitalized on the 16th.
Uh-huh.
And then she has letters that she sent on the 17th.
Okay, so the 17th is 3 days after the cartoon was received and at least the day after she was released from the hospital.
Day before she was released from the hospital.
She was released on the 18th?
Cartoon, then we have cartoon on the 14th. We have hospitalization on the 16th, released on the 17th, sentencing on the 18th.
So she writes this letter on the 17th and it's sent on the 18th. It's sent or received on the 18th.
The hearing on the 18th.
Mm-hmm.
And she sent it, I believe, on the 17th or 18th.
Okay.
I believe it's on the 17th, Judge.
Well, it's written on the 17th.
And sent off on the 17th.
Okay. Which is 3 days after the cartoon's received, and is it the same day she's released?
I think day after she's released.
Okay, yeah, that's what I said earlier. So a day after she's released from the hospital.
On the 15th, she gets out on the 16th, sent the letter on the 17th.
Okay. All right. Again, I don't see how this fits under 8031. The contents of the letter are specifically, it seems to me, requesting that the attorney contact the district attorney's office in Cobb County and alert them about what Ms. Merritt perceives as someone who maybe have been involved in the case in Cobb County, preparing and sending this flyer in the mailbox. I don't see how this falls under that hearsay exception, and especially considering the timeline of when the cartoon was received, when Ms. Merritt had the health issues, and when this letter was written and received by the attorney. So I do find that it does not fit under 8031. I do recall you making another offer under another code section, but I didn't write that one down. So what was the other one? 803, I got 807.
803, section 3.
Okay.
Mental, emotional, physical condition. As she states, I am very upset. That is in the present tense. That is her saying on 17th that she is upset, and she explains why she's upset within the contents of the letter.
And what is this probative of?
This is probative of her concerns and fears regarding the world outside, possibly having some impact on her and her loved ones.
And why is that relevant?
Your Honor, as the court knows, it's relevant to the defense, just as a cartoon, to show that there were people out there who obviously had a hate, disdain, vitriol towards Mr. Merritt that may have acted out and caused the death of Ms. Shirley Merritt.
Do you want to respond?
Again, I don't believe that it's relevant what her state of mind was relevant, is relevant to what happened in this case. I'm looking at the hearsay exception. I don't think that her state of mind, several days, over 2 weeks before the murder, is relevant, Your Honor, to what happened at the time that she was killed.
I don't either, Mr. Queen. So how is this relevant? How is Ms. Merritt's state of mind relevant to the question that this jury has to answer about who committed this homicide?
You know, again, like Ms. Merritt having fears of outsiders is relevant to show that there was a perceived, and then as we will say, an actual threat to her life out there.
A perceived threat to her life? In what way?
Judge, if you look at the letter, she's talking about she's fearful for herself, she's concerned about herself, she's concerned about the kids, her particular grandkids, she's concerned about her daughter-in-law at the time, Ms. Merritt Post. So Judge, we believe that goes to the whole idea that there may have been actual people out there, outside, who were maybe looking at her, looking towards her, looking to...
But the cartoon is not about Ms. Merritt. It's not... And here's the other thing. Because he's living with her, how are we to say that the target of the cartoon was Ms. Merritt and not Mr. Merritt? There's no indication on the cartoon that it was specifically sent to her or that there was any alleged threat to her. Your client is identified in the cartoon specifically. So, and again, I don't see how any concern that she may have had about her safety or the daughter-in-law's safety or the grandchildren, how that connects to this homicide. There's no forced entry, there's no indication, there's no testimony thus far about any defensive injuries on Ms. Merritt that would indicate that there was a struggle or that someone broke into the house or that there was some specific threat to her the morning or the day that this occurred. So I do think that you have to make the connection that there has to be some sort of relevance to this testimony about an alleged threat from outside. Now, we have the cartoon that's in evidence, and you can certainly argue whatever reasonable inferences flow from the evidence that's in evidence already that's been presented to the jury. But at this point, I don't see how this is relevant. And I don't see how it falls under any of the hearsay exceptions. I suppose as the testimony unfolds, that may change. I don't know. But at this point, I don't think that this falls under any of the hearsay exceptions that you've indicated. Anything further before I bring the jury out?
No.
Well, it's almost 12 already, so maybe we should just go ahead and break for lunch and start back at 1 o'clock. Other than your client, how many other witnesses will you have today?
No.
Yes, you bring the jury out. You all may be seated. All right, ladies and gentlemen, thank you for your patience. There are a few matters I needed to address with the attorneys before we start with the defense's case. It is 15 to 12 at this point, so I'm going to go ahead and release you for lunch. When you come back at 1 o'clock, we'll hear testimony from the defense, and we will continue on with the evidence in the case. So please remember the instruction not to talk about the case or allow anyone to talk to you about the case. And please meet the deputy out in front of 7A at the other end of the hallway. There is another trial going on in 7A. So if you'll just make sure that you kind of stay to one side so that we don't disrupt the proceedings down there as well. All right. Thank you very much. Have a nice lunch. See you all at 1 o'clock. You all can be seated. Mr. Green, just so that I'm clear and the record is clear, the Exhibit 3, how did your client come into contact with that exhibit?
The exhibit, we got it discovered from the state.
Okay. Did you not say that Mr. Willingham had shown it to him or provided it to him at some point?
They discussed it. Mr. Willingham, he has seen it. He has a copy of his own.
Okay.
But they've all discussed it.
So he discussed it with Mr. Merritt.
Right.
So Mr. Merritt didn't actually see the letter until...
Excuse me, I didn't mean to wrong. He's seen the letter when his mother did it. And then, of course, obviously living in the house, he's seen the letter because the letter was in the house.
I thought you said the letter was found at her bedside. So are you saying that he's going to testify that the letter was just sitting around the house and happened to end up on the bedside?
He doesn't know how I got to the bedside. He's seen the letter when she composed it. And then she composes the letter, it looks like on the 17th. And they discussed it. And he's seen the letter when she composed the letter. And then it appears that over time, she did some scratch outs and then she made some notes, which are on the bottom layer and continue into that other page.
So how do we know that that Exhibit 3 is the letter that was actually sent?
The typewritten portion is the part that Willingham received, the letter the attorney received.
Right.
He didn't receive none of the notes.
I understand. But my question is, how do we know that Exhibit 3 was actually the letter that was sent? How do we know that that's not a draft that she may have done, that she was working on because of the handwritten notes on it?
The type portion...
Here's my question. Would your client be able to testify that that is the letter that Mr. Willingham received? Because this is hearsay on top of hearsay, on top of hearsay.
No. Mr. Merritt cannot testify that is the exact version which Mr. Willingham received. Mr. Willingham, he would have testified that he believes the typewritten portion is what he received. Okay.
So under your theory that they discussed this letter, when would that discussion have taken place?
Around the time this letter was composed.
On the 17th?
When you say they, you mean Mr. Merritt? And
yes.
Yes.
I'm just trying to get straight in my mind that the letter itself is hearsay. And I don't think the letter itself falls under any exceptions to hearsay. But what I'm trying to get straight in my mind is if you're saying that there was some conversation between Mr. Merritt and the mother about the letter and about her feelings about the cartoon, then I think that's potentially
correct.
Admissible.
Correct. That's the impression, right, what I assume the court would find right. I guess, the demeanor regarding the conversations between Mr. and Ms. Merritt, I believe that'd be admissible. And obviously, the court, the contents of the letter itself and the actual letter, the court's ruling that that's not admissible.
Correct. So the letter itself is not admissible, but I do think that there is a possibility that you could establish that any conversations that they may have had around the time that the cartoon was received and potentially the letter prepared, that those could potentially fall under a hearsay exception. So that's what I'm trying to make sure that my ruling is clear that what I'm saying cannot be admitted is the letter itself.
I understand.
Okay. All right. We're on the same page. Okay. Anything further?
I don't have any discovery of what those statements may be. They haven't been provided to the state, which is required under the residual exception to the hearsay rule.
Well, the residual exception would only apply if the court finds that it doesn't fall under another exception.
I'm just trying to figure out, not knowing the statements, I don't know that we know what exception they would fall under.
I don't either, but
Okay.
I guess we'll see.
Thank you.
Okay. All right. Okay. All right. We'll be in recess till 1. And I expect that we'll finish a little early today, so we can go ahead and do the charge conference. And my expectation is we'll have closings in the morning at 9. All right. Y'all may be seated. Yes.
All right, we have Mr. Merritt take a stand this time.
I'm actually waiting for grand jury to come over so I can return the indictments first, and they should be walking in just a couple of minutes. Okay. Deputy Madison can stand by.
Okay, I'll do it.
All right, Mr. Merritt, if you'll take the stand, please. You all may be seated. Mr. Queen, is defense ready to proceed?
Sure, Your Honor.
If you'll call your first witness.
Your Honor, first, defense moves to introduce a self-authenticating document, which is a certified copy of warrant 19W001968. Move this introduce as defense exhibit number 2.
May I see that, please? No objection.
Admitted.
Next, Your Honor, the defense calls Mr. Richard Merritt to the stand.
Sir, raise your hand. Do you swear affirm the testimony you give the court will be the truth, the whole truth, and nothing but the truth, sir?
I do.
State your name, Mr. Merritt.
Richard Vincent Merritt.
And Mr. Merritt, where were you born?
Fort Belvoir, Virginia.
Did you grow up in Virginia?
Well, initially, so the first 3 years of my life there, my father was in the Air Force. He was career Air Force. He actually retired as a bird colonel after 24 years of service. But at the time I was born, we were stationed there. I believe it was at the Pentagon. We stayed there for about 3 years. When I was 3 years old, we moved to Maxwell Air Force Base in Montgomery, Alabama. Stayed there for another 3 years and went back to D.C., where we stayed until I was 13 when my father retired. And at that point, he took a job with McDonnell Douglas, which back then was one of the world's largest military aircraft manufacturers. We went and lived overseas in Saudi Arabia for 2 years. At that time, you could not attend school past the 9th grade in Saudi Arabia, so I came back and actually went my sophomore year at the Paideia School here in DeKalb County. And then my dad was transferred to St. Louis to company headquarters, where I spent my junior and senior year of high school. So I moved around a lot.
What's your father's name?
He went by Ken, but his full name was Robert Kenneth Merritt.
And when did your father pass?
He passed away in November of 2000.
And obviously, your mother's name was?
Shirley.
Do you have a brother?
I do.
And what's your brother's name?
Robert Kenneth Merritt II.
And is there an age gap between the two of you?
About 9 years.
Who's older, who's younger?
My brother would be the older one.
Now, growing up, what was the dynamics of the family? Was it just the four of you?
It was just the four of us. As I just mentioned, we moved around a lot. That was primarily when my brother had already gone off to college. He was in college by the time I was 3rd or 4th grade. So, but the dynamic when he was still around or came to visit was, we had a very traditional, conservative Southern military household. My father was, as I said, career military. He went on to be a successful businessman. My mother sold real estate, was very good at it. With her personality and natural intelligence, she was a star at it. And, my brother and I, we got along. My father definitely ruled the roost. He was the boss, but my mother certainly had her say too. It was definitely a partnership.
Now, when did you guys move to 1590 Players Road?
My parents bought that house in the summer of 1993. That would have been the end of my freshman year at the University of Georgia.
Now, is that where you went for undergrad?
Yes, I went to UGA.
And did you graduate from UGA?
I did.
What did you major?
I was a double major in English and political science, basically pre-law.
And did you go to law school?
I did.
And where did you go to law school at?
I went to law school at Mississippi College School of Law in Jackson, Mississippi.
Now, while you were in undergrad, did you meet a certain lady?
I met a certain lady. Her name was Janine Minicozy. I met Janine when she was a freshman and I was a junior. About a year and a half, maybe a little bit more than a year and a half older than her. But we met through a, we met through a mutual friend.
And how long did you date before you got married?
Well, early on, we dated off and on as kids do at Georgia, just enjoying the scene there in Athens. But as I proceeded into my senior year, it was, I guess, spring quarter of my senior year, getting ready to graduate, we became more serious and decided we wanted to stay in a committed relationship.
Now, by the time, what year did you get married?
We got married in 1999, about a week after I graduated law school.
And during that time, was she a veterinarian yet?
No, I believe she started her first year of vet school either my second or third year of law school, because she was still had a couple years to go when I graduated law school.
Now, by this time, when you got married, was your father still around?
Yes, he was.
And what year did he pass?
2000, about a year after we got married.
So during this time, did your mom help you out?
Yeah, they both did. At the time, I took me 3 attempts past the bar. I passed it the 3rd time. I failed the first 2 times. I did thankfully have a job as a project manager with a local internet company, so I didn't have the pressure of needing the license, although it certainly would have been nice to get that under my belt right away. But yeah, there were times when my parents helped us here and there while she was still in school, sure.
Now, after your father passed, what was the relationship between you and your mother?
Well, after my dad died, it was, as you can imagine, just my brother and I and our immediate family. We are close to a lot of extended family, had a lot of close friends. But in terms of our family, it was obviously just my brother, mom, and I, and we were close.
So what year did you and Janine get married?
1999.
And you have kids?
Yes.
And who are the kids?
The firstborn is our son Jack, and our secondborn is our daughter Mia.
Now, Jack, you've heard a little bit about him. Were you involved in his life?
Absolutely. Jack was the kind of son that every father wants to have. He was smart. He was a sensitive kid. He was creative. He was handsome. He was athletic. He was everything you wanted somebody to be. Just a real strong, special child. And he was my pal. I mean, we did everything at an early age. We went fishing. When he got older, we played a lot of golf. We went on trips, father-son trips. We went on trips with other dads and their sons that we were friends with. I went to all of his school activities, helped coach his baseball team, helped out with football. As I said, it was those big things that brought us closer, but it was the little things as well. Just going to Target or hopping in the truck and going for a drive, or things of that nature as well.
Now, Mia, I understand she has a disability. What's her disability?
Yes, Mia has cerebral palsy, and we did not know that she had a disability until she's about a year or so old. She was not reaching her milestones as the pediatrician wanted her to, and upon further testing, they realized that she had a form of cerebral palsy.
So you and your wife have to put her in programs for anything?
Yes, I mean, she required special schooling, special therapies. As she got older, she required speech therapy, occupational therapy, physical therapy. She had a walker and a wheelchair at a young age, and obviously as she grew bigger and taller and stronger, she had bigger walkers and bigger wheelchairs. But she's always going to require the aid of one of those devices and always going to require therapy. She's had a couple surgeries to help her perhaps walk better. She can't walk without the aid of a walker, and her speech is slurred and her development is delayed.
Now, were you involved with her therapies and in progress along with your wife?
Yes, as much as I could be. I mean, when I opened my firm in 2002, as you can imagine, is extremely busy. I was running my cases, trying to get new clients, attending court. It was just me to start off with. So those early years, I couldn't be at every single thing. That was the case when I was at a large firm before I opened up my own firm. So I went to everything I reasonably could, but certainly I couldn't be at everything. But the things I couldn't attend, we certainly talked about after the fact because I wanted to be involved in her life.
And you mentioned your practice. What type of law did you practice?
Well, in 2010, I opened up my own law firm, and before that I had been at a large law firm in Buckhead, but I've always been a litigator, primarily civil litigation, mainly personal injury, wrongful death, medical malpractice, and business litigation. When I opened up my own firm, I also did a little bit of criminal defense. I really didn't do felony work. I did a lot of DUIs, things of that nature.
Now, during this time, around 2010, and as the practice grew, what type of lifestyle were you and Janine leading?
When the firm opened in 2010? Well, we were a very sociable couple. We lived in a very diverse neighborhood in Smyrna, within walking distance to downtown Smyrna, where a lot of the restaurants and whatnot were at. The neighborhood was primarily people like us, two professionals, small kids, so there were a lot of children the same age as our children's ages. We got together for barbecues. We went to events together. We had each other over at each other's houses. There were a lot of sleepovers for the kids. Kids played baseball together in the local Smyrna Little League. So there's always something going on, whether it was a neighborhood event or going to some sort of lawyer event or an event associated with her veterinary practice. We were out and about.
Now, by this time, your father's passing, did anyone else live at 1590 Planters Road besides your mother?
No.
And up until her death, did anyone else live there besides you?
No.
Now, during this time, 2010, 2015, What was your relationship with your kids and your wife?
In 2010,
2010 to 2015. How was the family dynamic?
the only way to describe my family dynamic and my marriage was it was a dream. We were happy. We were fun-loving. We laughed a lot. You know, Janine and I did a fair amount of traveling. We were always doing things with the children. We didn't like to sit around and watch TV. We weren't that type of couple. We weren't sedentary by any means. I was always trying to promote her career, and she was promoting mine. A lot of times we'd find out that we had clients in common and didn't even know it. And it was just a very idyllic way to live, to be married and to raise kids, to be in a place that you enjoyed, around people you enjoyed, and to be building something, to be building a future.
Now, in 2018, what happened?
In 2018, I was arrested in Cobb County for multiple counts of theft, forgery, and there were some counts also of elder exploitation because I did steal money from some elderly folks.
Now, your arrest, was that a big deal in Cobb County?
Yes, it was a big deal in Cobb County. Just a little bit of background. I was one of the few lawyers in Smyrna, and Smyrna has grown a lot since I started my practice in 2010, but it was right on the little village square across from the courthouse. I was the only firm there. That was part of why I picked that area, because I saw a need. I wanted to be the local lawyer that people went to first for help. And it was a very successful vision. And so the practice grew. And when things went south quickly and I got arrested several years later in 2018, it was a shock to our neighbors, the local community, and to the Cobb County Bar.
Now, when you got arrested, how many times did you get arrested?
Actually, the first time I got arrested in connection with the Cobb County fraud was in April of 2017. It was shortly after spring break that year. We had just gotten back, and I had a letter from the Cobb County Magistrate Court telling me that I needed to appear at a warrant application hearing. And what that basically means is somebody has taken out a warrant for your arrest, and a judge has to determine if there's probable cause or not. So this hearing was on a Monday morning, and I went to the hearing. It happened to be two of the older ladies who were victims in the main arrest in January of 2018. They had taken out a warrant for one account of theft by conversion, alleging I'd stolen $70,000 of their settlement money. We had the hearing, and the judge found that there was probable cause. So the judge said, well, I'm going to set your bond at $2,000, and I will give you until tomorrow morning at 9 a.m. to appear at the Cobb County Jail. I left court. When I saw Janine that night, I told her, as soon as I saw her, after the kids were in bed, I said, I need to tell you something. She said, what? I said, I have a warrant for my arrest. And I explained to her what it was. I said, I don't know the extent of it. I know they're claiming I stole $70,000. Need to figure out more about it. But in the meantime, I need to appear at the Cobb County Jail tomorrow morning at 9 a.m. And so the next morning, she went with me early to James Bond Bonding Company, one of the bonding companies up there off of County Services Road. And we filled out the bond paperwork. She was the surety on the bond and paid the $200 some odd down, which is the 10% of the $2,000. And I turned myself in at the Cobb County Jail shortly before 9 o'clock and was out by 2 o'clock that afternoon.
So the first time she bonded you up?
Correct. Janine knew that I had been accused of a felony theft. She knew that I had booked in and out of the Cobb County Jail, and that was the last we ever discussed it until I was arrested along with everybody else, all the other victims, I should say, in January of 2018.
So the second time, did she provide any assistance to get you out of jail?
No, she did not. To say she was less than pleased would be a vast understatement. I was driving to deliver papers to somebody the morning of January 31st, 2018. Several months earlier, I had voluntarily surrendered my bar license. The bar had been investigating this. I knew what was coming, and it was just odd to me that I had never received an invitation from a detective to talk about it or anything like that. They just built their case, and then wham, there it was. So that's how they chose to proceed. But I was arrested on January 31st. I was, as I said, going to deliver some papers. A Cobb County Sheriff's Deputy SUV pulled up behind me, blue lighted me. I pulled over in a Taco Bell parking lot, and several unmarked Crown Vics appeared as well. I didn't learn until several hours later the scope and extent of what I was being charged with. I reached out to her from the jail. I knew, based on my experience as a lawyer, that I would not be bonding out in the next few weeks, and sure enough, did not have a formal bond hearing before a Superior Court judge until about 2 weeks later. But Janine was very upset, didn't understand what was going on, which is certainly understandable. I frankly didn't know the extent of what was going on, although I had a pretty good idea. And that was her reaction at the beginning of that whole process.
So that case, how many victims were there?
There were 15 victims and 34 felony counts.
And you mentioned, how long did you sit in jail waiting to go to court?
It's about 2 weeks, maybe a little less.
And did you end up having to hire a lawyer on that case?
I did.
And who was your lawyer?
David Willingham.
And were you able to pay him, or did somebody else pay him?
At that time, funds were extremely tight and limited. I was in the Cobb County Jail. Janine was scrambling to try to make sense of what was going on and take care of the children. So my mother graciously offered to assist with his initial fee payment.
And what was your mother's general demeanor and feelings at this time?
My mother was upset. She was disappointed. She raised me better than that. And she had every right to be upset with me. It was a disgrace. And there's no excuse for my behavior. But she was upset. But at the same time, I was her son. She truly did believe that one should hear out all sides of a situation before making an opinion. And she gave me the benefit of the doubt. And her goal was to help me get out, and then I would get a very stern talking to once out. But her goal at the time was just to support me and try to help me get up the bond money.
How much was your bond?
The bond was $400,000. The down payment for the bond in order to actually get me out was 10%, so that would have been $40,000.
How was that?
My mother, it took about 2 months, but what she ended up doing was taking out a home equity line of credit, basically a second mortgage on her home, in order to come up with the $40,000.
So ultimately, how much time lapsed between your getting a bond and getting out of jail?
I believe it was about 65 or 66 days.
And what were the conditions of your bond?
Well, the bond conditions were as follows. I was to have a curfew of 5 p.m. to 8 a.m., which meant obviously I had to be back at her address. I had to live at her address, first of all. That was the first bond condition. Second condition was I had a curfew of, as I mentioned, 5 p.m. to 9 a.m. So I had to be back by 5 p.m. and I couldn't leave the next morning till, it was 8 a.m., 5 p.m. to 8 a.m. Obviously, I had to reside at her home in 1590 Planters Row in Stone Mountain, DeKalb County. I wasn't to drink any alcohol, do any drugs without a prescription, not to break any laws of the state of Georgia, pretty standard stuff. They also had me surrender my passport within the first 24 hours of release, which I did, and I was required to wear an ankle monitor.
Now, once you were released, what was the relationship between you and your wife?
It was very contentious. She felt that I had led a double life. She didn't understand why I took money from these people. She was upset. She was shocked. We went from having an idyllic life to having nothing. despite my urges to try, it was decided that she didn't want to stay in the home, so we let the house go. It was a very nice house that we loved and had lived in and raised our children in and planned to stay in a long time. So the house was gone. She decided to move into a rental home in East Cobb and Marietta, where the public schools are quite good. And my son had attended the Lovett School, which is a private school, but he wasn't going to be able to go there anymore. My daughter went to public school because of her disability, so thankfully she could attend school wherever she wanted, based on having a disability. But it was a major upheaval. I mean, overnight it was as if a bomb went off in our lives.
And at some point in time, did she file for divorce?
Very quickly, she filed for divorce 4 days into my arrest.
And did that divorce ultimately, was it complete?
Yes, the divorce was finalized, I believe, third week of June 2018. And I didn't fight her on the divorce. I understood her emotions. I understood the reasons for it. I certainly didn't want her to be accused of having any part of my misdeeds, because I truly did act alone. She wasn't involved. I think early on some folks may not have believed that, but it turned out that the divorce not only was what she wanted emotionally, but perhaps helped out in segregating, my behavior from, obviously her not having an involvement.
Now, after your release, what was your relationship with your kids?
My son was 14 and a half at the time, and as I said, we were very close, and he had me up on a pedestal like a lot of boys do their father, and he was upset with me. He yelled at me, he ignored me, he cried, he was hurting.
There's no relevance to his kids' feelings.
We've heard from Dr. Minicozzi, and she went into detail about the things that the son felt, things that the son did, and things the son told her during this time period.
But that doesn't make it relevant. So how is this relevant?
Judge, I'm involved.
All right.
But your mother, by this time you're living with your mother,
Yes,
and you're out of jail.
correct.
What was your relationship with her?
She wasn't pleased with my behavior. She was embarrassed, but at the same time, she was willing to give me a chance, give me a place to live, help me survive. I mean, I really didn't have much other than my personal effects and an old pickup truck, literally. So she opened up her home to me, and it was strange being back under her roof at, I guess I was 43, 44 years old when all this went down. But, it after the first several days and weeks, we got into a routine, and it was fairly normal under the circumstances.
Did you and your mother argue, fight?
My mother's a very strong-willed person. I believe the term firecracker was used, and that is a very good term. I would throw another one out there. She's a steel magnolia. My mother is a strong Southern woman, and she had no problem telling me what I thought, what she thought, rather, down to what I wore, to my opinions on certain things. But it was certainly not toxic. We were both opinionated people. We spoke our minds. But we also laughed a lot and spent a lot of time together. So there was nothing abnormal to me or her about it.
Now, as your criminal case made its way through the process, did you start to feel some external pressures?
You mean as we got closer to sentencing? Yes, it was a very odd time. Starting in, I would say, right around the 1st of January 2019, my sentencing hearing had been set way back in September of 2018. I actually wanted a plea earlier and get on with it and get on down the road to prison, but the DA at the time in Cobb County wasn't ready yet. He wanted to make sure there weren't any more victims, which was fine. It's certainly his prerogative. So there weren't any more victims, and then the plea date was set for in September, the plea date was set for January 18th of 2019, a Friday. And right about the 1st of January 2019, my mother's house kind of sits up on a cul-de-sac, and you can see the whole cul-de-sac. And I saw an abnormal amount of cars pulling slowly through, stopping in front of our home. My mother noticed the same thing. I began receiving hang-ups on my cell phone, numbers I didn't recognize. Some said unknown number, but area codes and numbers I didn't know. My mother was receiving the same thing. She showed me her phone, wanting to know if I knew who these numbers were, and I didn't. And this seemed to go on with some frequency up until January 14th of 2019.
Now, during this time, were you speaking with your wife?
Yes, of course.
And likewise, does she have concerns?
I believe, if I recall correctly, she did. The victims in this case have been characterized, and I don't mean this disrespectfully, I'm just trying to answer truthfully and honestly. The victims have been characterized as...
Objection, Your Honor. What the victims have been characterized as is not relevant. I don't know if that's hearsay or where he's coming up with this, but I don't believe that that's relevant.
And they're not victims in this case. There's
No.
only one victim in this case.
Correct.
So how is this testimony relevant?
I'll move forward.
All right, I'll sustain the objection.
Now, were you ever, you were following?
Yes.
And did you ever feel that maybe somebody was out to get you?
Absolutely. No doubt about it.
Now let's talk about, at some point in time, as we've seen, President No. 1, a cartoon arrived.
Yes.
And what day was that?
That was January 14th, 2019.
And who received that cartoon?
That cartoon was received at my mother's home at Planters Row in DeKalb County. It was personally delivered in her mailbox and discovered by her.
Did you have discussions with her about it?
Right away. I believe, on my way to work. I was working at a warehouse at the time, and I received a call from her informing me of receipt of this cartoon, and she was upset. And literally, as I hung up with her, I received a call from my ex-wife, Janine, who you've heard from, and she was upset. And what was concerning to me, because it was directed at me as well, not only in the substance of the cartoon, but obviously had to deal with something I was involved in Cobb County. What concerned me was that these are copies of the same cartoon being delivered 40 miles apart, two different counties, with a county or two in between these counties. And it was a concerted effort, whoever delivered them.
Now, within a day or so, what happened to your mother?
Well, actually, it started the night that she received the cartoon. I got back, and she was upset. She started feeling dizzy, having difficulty breathing, having chest pain, and she just was very concerned about the cartoon, about the effect on Janine and the kids. And I should add that Janine felt as if, she didn't feel. She was quite adamant that she was keeping my son Jack home from school the next day, and she wasn't going to go to work. And she had called somebody at the Cobb County DA's office or sheriff's office, and I'm not sure which, to inform them of it. And my mother was concerned that they weren't going to do anything, and in fact, they didn't. So there was definitely concern on both sides. My mother had these symptoms. She decided that she needed to go to the ER. Well, I had the ankle monitor on, and the curfew had been moved back to midnight because I had started a job at Petco warehouse up in Gwinnett County, and in order to make my hours, I had to be able to get the curfew moved back, which my pretrial officer, basically my probation officer, was happy to do because they want you to have a job. So long story short, I wasn't still going to be able to drive her because my mother really didn't make the decision to go to the hospital until probably 10:30, 11 that night. There's no way I could take her there, drop her off, and get back and not be in violation of my monitor. So she was able to drive herself. They admitted her, and I think she was admitted at early morning hours of the 15th, and she was discharged sometimes on the 16th.
Now, after she was discharged, did your mom still have concerns?
It was all we talked about. She got back home that Wednesday when I first encountered her. I remember distinctly sitting at the kitchen table. We were a kitchen table family, so discussions were had at the kitchen table or around the kitchen counter, around the island where the sink was. So we talked about it. And back a few days earlier on Monday, I had taken a picture of the cartoon on my phone and sent it to my lawyer, David Willingham, so he was aware. And if I'm not mistaken, he received a copy as well as something else.
That's speculative hearsay. I don't know that he has personal knowledge of it.
And Mr. Queen, this is turning into a lot of narrative. So you need to either ask some specific questions or instruct your client to confine his answers to the questions that are asked. So I'll sustain the objection.
Yes, ma'am. So, what did your mother do in response to the cartoon as it relates to the attorney, Mr. Willingham?
She began to draft a letter to Mr. Willingham.
And to your knowledge, was that letter delivered?
To my knowledge, it was.
On what day was this? What day? What is January 15, 16, 17? What day are we?
I remember her showing me a draft of the letter quite soon after she got home because my mother was the type of person to handle stuff while it was fresh on her mind. So she showed me a draft of it. I said, do whatever you want, send it. And I have no reason to think that's not what happened, and it did in fact happen.
Now, what day was your sentencing hearing?
Friday the 18th.
And how did that go?
It was quite an event. Court that day was to start at 9 a.m. and it lasted all day.
Did you ever plea on that day?
I did.
Did the victim get an opportunity to express their opinions regarding your sentence on that day?
They certainly did. And the way it worked that day is I showed up and entered my plea, but there had not been an agreement on the precise sentencing. I rejected the state's initial offer. The judge assured us that he would not go more serious than that offer. So the hope was maybe I would end up getting a little less time than what the state initially recommended. The judge heard testimony from the victims all day. I believe I was the final person to testify. And then the judge pronounced his sentence 4:35 in the afternoon.
Now, you said you testified. Was it a trial?
No, it was not a trial. I pled guilty in the first few minutes of the proceeding. The rest of the day was simply about the judge hearing from victims, hearing from me, and making a decision on what he wanted the sentence to be. There was no question about my guilt at any point.
And what was the sentence?
The sentence was 30 to 15. Plus, I had to pay back $526,000 in restitution.
Now, And did you go to jail that day?
No, I did not.
When were you report to the jail?
The judge was gracious enough to give me 2 weeks to report, which would be February 1st by 5 p.m. at the Cobb County Jail. And he made it abundantly clear what would happen if I did not show up.
What would happen if you didn't show up?
If I did not show up, he would revoke my sentence, and it would be a serve 30 sentence, which could affect parole and all sorts of other things. So the sentence would be much harsher if I did not appear as scheduled and ordered.
So after sentencing, what did you do during this period of time between the sentencing and the day before the show up?
Well, that day, just starting off with how it was handled, I mean, I wasn't surprised. I wasn't upset. I accepted my punishment, and my mother and I got in the car and we left and went back to her house in Stone Mountain. That weekend, we kept the kids. I spent time with my children like I did a lot of the weekends during my 10 months out on bond. They wanted to see me, I wanted to see them.
So did you have an opportunity to spend time with your kids while you were on bond, even after you took your plea?
Absolutely. That was an area where Janine and I were thankfully in agreement. She made it clear to me, both in and out of the Cobb County Jail during that 60 days I was trying to make bond. She said, if the kids want to see you, I have no problem with you seeing them. And I saw them above and beyond the former divorce settlement agreement. There are many times that I kept them while she did things with her friends, and there really weren't any issues. We communicated, and if I wanted to see the kids and it worked out, great. If not, then so be it. I'd see them next time.
Now, your wife testified regarding the night before you returned yourself in.
Yes.
And she mentioned that you went to the Starbucks. Did you meet her at the Starbucks?
Yes. My son Jack expressly wanted me to pick him up at his school in Buckhead that Wednesday and Thursday to try to get as much time together as we could. And I certainly complied with that and wanted to spend time with him. That Thursday, we went for an early dinner. I took him to the Longhorn Steakhouse in Kennesaw off of Barrett Parkway. We finished kind of early. We walked around the REI sporting goods store because we both enjoyed outdoor things together.
Jack, these have become very, very non-responsive. I just ask that he answer the question and not go beyond that.
Mr. Merritt, you need to confine your responses to the questions that are asked. If you don't understand the question, ask that it be clarified.
Yes, Your Honor.
So when you met at Starbucks, were you already with Jack?
Yes,
And when your wife arrived, did she have a meal with her?
she did.
Was there any animosity between any of you?
No.
And let me go back for a moment. By this time, you were in the process of a divorce.
Yes.
Your wife mentioned about an incident. She says that you pushed her down. While you were out on bond, did you ever push your wife down?
Absolutely not.
So let's turn your attention to February 1st.
Okay.
That morning, did you go to your daughter's doctor appointment?
I did. Janine had told me about a pediatric neurologist appointment that my daughter had it was early. I think it was 8 a.m., maybe even a little bit before.
And at that point in time, were you still on curfew?
I was.
So what time were you able to leave the house?
I could not leave a second before 8 a.m.
And the doctor's appointment, where was it?
Sandy Springs.
So what's the route you would take to get there from Planet Burn?
Well, really, the only way to go would be to leave the neighborhood, make a left out of the neighborhood, get back to Hugh Howell, get on 78 to 285.
Now, did you get there on time?
It would be impossible to get there on time, but I got there as soon as I could.
And were there any problems between you and your wife when you got there?
No,
And did you get a chance to see me?
I did. They were already seated with the doctor. I walked in, said hello to everybody, gave me a hug, and sat down and listened to what the doctor had to say.
Now turn your attention to Mr. Jeffco. What's your relationship with Mr. Jeffco?
Mike is technically some degree of a cousin, but we come from a large family where, we don't really get in all that. And I knew Mike my whole life, and we were close.
And was there understanding for Mike to originally take you to jail?
Yes, I believe Tuesday or Wednesday that week, my mother and I decided that it would probably be best at that time when we had the discussion that Mike come and take my mother take me to the Cobb County Jail.
Now, is it that your mother didn't know how to get there?
No, my mother had been to the Cobb County Jail plenty to visit me and to go arrange the bond.
So, what caused things to change with that plan? Mr. Jeffco to take you?
Right. Thursday night, after I got back from seeing the children, my mother and I were talking, and we just felt like it was a private family matter, an intimate family matter. Even though Mike was family, it was something that she and I wanted to share and handle. That was really all there was to it. We didn't want to inconvenience him.
So did you ask your mother to call Mike off?
We both decided that it wasn't necessary for him to be there.
And why is that?
Because we didn't want to inconvenience Mike, because we actually had a few things we wanted to talk about, and we just frankly didn't need anybody else's help.
So the morning of the 1st, what time did you get back to the house?
Oh, around 8:30, I think, somewhere in there, 8:30, 8:45.
And tell us what happened that day.
So when I left the doctor's appointment and was driving back, it was the last time that I saw Mia before I knew I had to turn myself in later in the day. Mia was my baby girl. She's my princess. So naturally, I was sad. It was a sad ride home, just like the night before after saying goodbye to Jack. When I walked into the way that you got back into my mother's house is that I would park my car in the driveway. Her car was in the garage. If the garage door wasn't open, I'd open it and walk through the garage door into the kitchen. So I walked into the kitchen. I'm sorry?
How would you open the garage door?
The garage door opener.
Did you have a separate garage door or was it on the panel on the door?
No, it was in my car. Yeah.
So once you opened the garage door,
I went inside, and it had been obvious that I was upset. I had tears in my eyes, and she just came over and hugged me. She knew why I was sad about saying goodbye to my children.
and then what happened later that day?
Well, shortly thereafter, she sent Mike the text saying that things aren't so good here. And that's exactly what it was about. It was just not a happy day. I mean, I was about to go away to prison for possibly 15 years. So it was a private time. There was no yelling or screaming. And I sent him a similar text, and that was that. So after those texts were sent, I started to go through some of my stuff and sort through some of my personal effects. And my mother and I, oddly enough, I had been so busy spending time with the kids and doing other things. She and I hadn't had a discussion about how to organize my clothes or what maybe to sell or any of that kind of basic housekeeping type of stuff. Those were things we needed to talk about. That's what we mentioned in the text when we said we need to discuss things. That's it.
Now, was there a plan for y'all to have lunch together?
Yes, my mother was a great cook, fantastic cook, and she was going to make spaghetti.
So did she start preparations for lunch?
Yes, she did.
And then what happened?
It was, the plan was we were going to eat around 1 o'clock so that we could be on the road by 2, no later than 2:30. It was, I believe, Super Bowl weekend, Friday afternoon traffic, a bunch of stuff going on in Atlanta. And, obviously we don't want to be late to the jail, given the importance of me being on time. I was walking from the kitchen. I had just left the kitchen from keeping her company while she was making the spaghetti when I heard a very loud knock at the front door. We weren't expecting any visitors. So I went to the front door and I opened it. And there were two individuals there, two men, and they both were pointing pistols at me. And they told me to let them in.
So what'd you do?
I let them in. I had never seen these guys before, and they were pointing pistols at me, so I let them in. I let them in. They shut the door. About this time, my mother came to the foyer where I was standing with these two individuals, and they said, head to the basement and don't say an effing word.
So did you go to the basement?
The taller of the individuals, he was older, probably in his 50s, about 6 feet, athletically built, walked past me, put the gun at my mother's lower back, and she started to head towards the stairway to the basement. The fact they said head to the basement led me to think they knew we had a basement and had cased the house before. The younger of the men, he's probably about 5'8", 5'9", shoulder-length brown hair, pudgy. He put his gun on my back and we followed them. She opened the stair door to the basement, flicked on the light. It was a two-step process to get down those stairs. You had 4 or 5 steps that went down. There's a landing, and then you make the turn, and there's the longer flight of stairs. They proceeded first. My mother was crying. She was making sounds like she might be wanting to scream or shout. And as they made the turn on the landing and took those first few steps, by this point, I and the guy behind me who had the gun on my back made it to the landing. He told her to shut the F up and pushed her down the stairs.
And then what happened to your mother?
It was the worst sound I've ever heard in my life. She plunged headlong into the wall. It's a sound I can hear to this day as I'm sitting here. And I could tell that there was a dent or a hole in the wall. She was trying to get up and move around, but from my vantage point, she appeared like she couldn't get her balance.
Was your mother injured at that time?
She certainly appeared to be. And as I moved like I was going to try to go down the stairs, the guy dug the pistol into my back and grabbed my shoulder. The gentleman who pushed her down the stairs put his pistol behind his back into the back part of his jeans. He ran down the stairs, turned the corner, and came back with the 35-pound weight that has been seen during the course of this trial.
And where did the knife come from?
Well, the knife came later. This monster took this dumbbell and proceeded to bludgeon my mother right in front of me. And she stopped moving at this point. He then told the man who had his pistol in my back to bring me down to the bottom of the stairs. They shoved me over to the tile where the dumbbell rested. And then the older guy took off up the stairs. He came back a few minutes later with the kitchen knife and proceeded to stab my mother repeatedly in front of me. I cannot believe what I was seeing. I didn't understand what would be the purpose because she wasn't moving. Why is any of this happening? It was a complete and utter nightmare.
So what did you do during this time?
There's nothing I could do. I had a pistol to my back. I couldn't believe this was happening. I had no clue who these people were or why they were doing this to us. So he stabbed her with such force that the handle broke off the knife. I didn't realize at the time that the knife was still stuck in my poor mother's face. He put the handle down on the tile across from the dumbbell. He then turned and looked at me, and he pulled out his cell phone. And he proceeded to show me a picture of my ex-wife dropping Mia off at her school, a picture of Jack being dropped off or picked up at Lovett, a picture of them all getting out of her van at their rental home in Marietta, and a picture of her either coming or going from her clinic in Vinings. And he said, and I'll never forget this as long as I live, if you say a single word, they're next. I had no doubt who they were or what next meant. And then they left.
And then, did you call the police?
No, I did not call the police.
Why not?
Because I just witnessed an unimaginable act of violence. 2 unimaginable acts of violence. And then a man coldly looked at me after he's standing over the body of my dear mother that he skewered and bludgeoned, and shows me pictures of my family. So no, I did not call the police.
How much longer did you stay there?
I stood there numb and incapable of moving for what seemed like minutes. These guys had left. I went upstairs. All I could think about was Janine and the kids and what these monsters could do. And I went and got a small backpack out of my room. I put a few clothes. I didn't pack much. Some basic toiletries. And I left.
Now, why did you take your mother's car?
I took my mother's car because it had more gas in it than my car. It had a bigger tank. And I had no idea where I was going or where I was going to end up. And it seemed to me in that state of mind that at least her car would be easier to sleep in. And that's why I took her car.
So where'd you go?
When I left her house, I went out of the neighborhood. I don't even know what time of day it was when I left, but I went out of the neighborhood. I made a right and went up, I believe it was called Rock Bridge, but it becomes Five Forks Strickland. We're right at the DeKalb County, Gwinnett County line. And I made a left. I'm not sure if it was Arcata or Killian Hill, but up by the Kroger there, and just started heading towards 85.
Now, how much time did it take you to get to Nashville? Is that where you go? You go straight to Nashville?
No, I didn't go all the way to Nashville in one shot. No, I ended up going to the QT station at Indian Trail in 85. I stopped to get a couple bottles of water, some snacks. I only had $18 cash on me. I topped off the tank, I believe, put some gas in it, and then I proceeded towards Cobb County, towards 285, and then ultimately to 75.
Why did you cut your monitor off?
Well, the reason I cut my monitor off is I was concerned by the time I got north of Cobb County, I was within, I believe, an hour or so of when I was supposed to report. I had no idea if just by routine the monitoring people were watching me or not. So that's why I headed towards Cobb County. I didn't want to do anything that would get me involved with the police because I didn't want it to come back to hurt my family if these guys found out and thought I had said something.
Now, why did you take both phones?
For that very reason. I had every reason to believe, based on this horrific event, that these individuals had a lot of hate for me, had been following me and or my ex-wife and kids. And perhaps they had our numbers. Perhaps they were the ones who had been calling and hanging up. I didn't know. I wanted to have the phones in case they had demands. If they went back to the house, I had to know what was going on. And if Janine called either myself or my mother, I wanted to know what was going on with her, that she was okay, that the kids were okay. So that's why I took both phones.
So how long did it take you to get to Nashville?
Ultimately, I probably got to Nashville. I mean, I think they're an hour behind, but I ended up in Nashville after dark. Of course, it was wintertime, so it gets dark early everywhere, but it was probably 7, 8 o'clock Central Time by the time I actually got there.
And why did you stay in Nashville?
Nashville is a big city. I had no more money to buy gas, and it seemed like a safe place to pull off and park and try to figure out what in the world was going on.
And eventually, did you get a job in Nashville?
Yes, I got a job at a bar called Betty's Bar and Grill on the west side of Nashville.
And you heard yesterday, well, last week from Kelly Richardson. And how'd you meet Kelly?
I met Kelly online.
And did you start living with Kelly?
Fairly quickly, yes.
Were the two of you in a relationship?
Yes.
Did she know who you were?
No, she did not.
And why didn't you tell her?
I did not tell her because, again, in my mind, with how horrific the events of my mother's murder were, how graphic the people were capable of such insane violence, I had to believe that they would keep their word and take it out on my ex-wife and my children if anything was said. So I adopted a new identity, and I made a vow to myself that I would never reveal who I was. And there were many, many times I wanted to Kelly, but I wanted to tell her that I was accused of a murder I did not commit. But I didn't, because I didn't want to endanger her, and I didn't want to endanger Janine and the kids.
Now, Kelly, did you and Kelly ever have any problems, anything violent between the two of you?
No, absolutely not.
She was telling us that around about the date in which you got arrested, that she wanted you to move out or stay somewhere else. What was going on there?
Kelly, at the time, was a PhD student in chemistry, and she had a lot of work to do, and she needed her space. It wasn't relationship space. It was, hey, just go find somewhere else to be for a day or two so I can get my project done. That's all it was.
Now, by that time, what happened to the car?
I want to say it was the Wednesday or Thursday before I got arrested. I got arrested Monday, September 30th, 2019 in Nashville by the Marshals. I want to say Thursday the 26th, I woke up. I believe Kelly was already in class or at her lab, and the car was gone. Kelly lived in an attic apartment in an old house on 18th Avenue near the university, and I didn't know it, but apparently there were a lot of break-ins, and learned after the fact that the car had been broken into, and during investigation of it by the Vanderbilt police, the car got towed, and that's what ultimately led to my capture. So I woke up, walked out, the car was gone.
So did you have anywhere to stay with the car being gone?
Not right off the bat, no.
Tell us how you ended up getting arrested.
Yeah, on that Monday, I was, the weather was starting to change in Nashville. It was getting cool at night. I was walking in West Nashville in an area called Sylvan Park where Betty's was and a few other places that I knew. And there was the old Southern thrift shop, which I had bought good cheap clothes before. And I was just looking for a light jacket because I didn't have one. And as I was done browsing through the store. I didn't see one. I started to walk out, and next thing I knew, I was surrounded by 5 or 6 marshals, and my face was in the floor, looking up at them. And they told me I was under arrest.
So, Richard, getting back to February 1st.
Yes.
Did you kill your mother?
Absolutely not. I loved my mother. She stood by me. I'm not a violent person. Never laid a finger on anybody.
None further.
We'll be in recess for 10 minutes.
I don't really know.
Judge, can I ask about something totally off the record?
Sure.
I'm not sure if you were in the email train between myself, Mr. Pines, and Mr. Cross.
No. About?
What's the young man's name? Antoine Gordon.
Yes,
That
Ms.
case,
Shaw.
And Ms. Shaw. Apparently there is a similar issue going up to the Supreme Court of Georgia. And there's email, I guess, between us and maybe Ms. Johnson asking if, because Pines is out of town that week, one that. I'm here that week, but they're asking to see if that case can be taken off the calendar while that pending related issue is being resolved in the Supreme Court of Georgia. Pretty much for the drug overdose. And apparently there's a case going up. I can forward you the email, I'm not
Yes.
sure.
Yes. Why don't you do that? And I'll take a look.
Okay.
Okay.
Will do.
Y'all may be seated. Ms. Potter.
Mr. Merritt, what you said happened in front of your eyes on February 1st, 2019 must have been horrifying for you.
It was.
You said that it shook you up.
Absolutely.
You were afraid for your own life?
I was so traumatized by what happened to my mother, I really wasn't worried about myself at that point.
Okay, but you were concerned for your wife and your daughter and your son.
Yes.
And you were so scared that you got out of there as fast as you could. Right?
I did.
Okay. Made the decision not to turn yourself into the Cobb County Jail, right?
Correct.
And instead you cut your ankle monitor off.
Yes.
But before you even did that, you made some stops along the way. You stopped at a Kroger on... You stopped at a Kroger first, correct?
No, I didn't actually stop there.
Okay, but you stopped in the parking lot and you drove around the parking lot in the Kroger, right?
Correct, I did.
Okay, because you didn't need gas at that point because your mom's car was full enough to get you out of there. That's what you testified to, correct?
To get me most of the way there, yes.
Okay, and then you stopped at a QT in Norcross, and we saw the video of that. Do you recall?
I did.
Okay, and you were there for how long? Do you remember?
I honestly don't remember.
Okay, did you feel that you were being chased at that point?
At that point, no, I did not.
Okay, did you feel like your life was in danger at that point?
I didn't know, honestly.
Okay, so you bought waters and a candy bar.
Yes.
Okay, and then you drove around 285 West, and you took the 75 North exit, right?
Correct.
Now, tell me if I'm wrong, but your wife's practice is over in Vinings, kind of on West Paces Ferry and Paces Mill. Is that correct?
Yes.
Okay, and so you passed that exit when you got onto 75 North.
Correct.
And you did not stop to tell your wife that you had just watched your mother being killed and her life was in danger. Correct?
No, I did not.
Okay, and your son's school, Lovett, is just down the street from that. It's on West Paces Ferry, is that right?
Yes.
And you did not make any efforts to take that exit, which is the exit before the exit to your wife's veterinarian clinic, to pick up your son from school or alert anyone that his life was in danger.
My son, I believe, was with his grandfather that day. He wasn't at school.
Okay, but you never made any phone calls to your wife? Correct?
No, I did not.
You never called Jack's school, right?
No, I did not.
You never called Mia's school, right?
No, I did not.
And so Jack was with Sal, that's your previous father-in-law. Did you ever call Sal Minicozy to let him know that you had seen this horrible event and that he and your entire family were in danger?
I didn't call any of them because the killers told me don't say a word to anyone, so I took them at their word based on what they did.
Okay, but they weren't following you, right?
I don't know if they were following me or not.
Okay, all right, so they could have very well been behind you.
It's entirely possible. I have no idea what vehicle they were in.
Okay, and a safe place to go would have been the Cobb County Jail, which you drove right past on 75 North. Is that correct?
The instructions were, and I took them at their word based on what they did to my mother, don't say a word to anyone. The last place to go would be to somewhere like the Cobb County Jail.
And why is that?
Well, you have law enforcement there. If they have people in Cobb County, they know a report. I'm more likely to say something because I'm in the safety of the jail. That made no sense to me whatsoever.
Okay, so you didn't make any calls to anybody to warn them that their lives were in danger, right?
These gentlemen told me, and I use gentlemen very sarcastically, these monsters told me, don't say a word to anyone. After what they did to my mother, I didn't say a word to anyone, without qualification.
Okay, so these monsters, do you think that they were the same people who had been casing your house starting at the beginning of January?
Well, they sure knew we had a basement right off the rip.
Okay, and how many times had people driven off around the cul-de-sac, or driven around the cul-de-sac as you testified earlier?
Suspiciously, at least 20 or 30 times by my count.
20 or 30 times? Did you ever get any of their tag numbers?
It would have been possible to run out there in the dark and get their tag numbers.
Did you ever call the police to say, oh my gosh, somebody is following me? Did you ever do that?
Actually, my mother and I did discuss it.
You discussed it, but you never called the police, and you never made a report of people casing your house or running around the cul-de-sac in their cars, right?
No, we didn't.
Did you ever talk to any of the neighbors about what was going on?
I didn't. I can't say if my mother did or not.
Okay. So you weren't concerned at this point about these people riding around in the cul-de-sac because you obviously didn't do anything to prevent it from happening in the future.
Quite the opposite, ma'am. I told my lawyer immediately when it happened, who did absolutely nothing.
Okay. All right. And you knew he did absolutely nothing.
He told me he was actually going to reach out to his contacts at the DA's office, where he used to work alongside the person who prosecuted me, as well as his contacts with law enforcement in Cobb. They all did absolutely nothing.
Okay. But did you ever call DeKalb County Police? Because that's where your mother's house was located.
No, I didn't call, and neither did my mother, to my knowledge.
Okay. And you understand that DeKalb County Police would have jurisdiction over your mother's house?
Of course they would, ma'am, but the root of the activity was all indications sourced out of Cobb County.
All right. So these two, you called them monsters, right?
Yes.
You've never seen these guys in your life?
Never.
And they were both kind of big. You said one was pudgy. What about the other one?
He was athletic and thin.
Okay. And could you describe what they were wearing?
Yes, I can.
What was that?
The athletic thin one was wearing sort of a black thermal long sleeve top and what looked like dicky khaki pants.
Okay. And what kind of gun was he holding? Could you see?
I'm not a gun guy, but it was a semi-automatic, sort of like the police have. It was not a revolver.
What color was it?
It was black.
All right. And what about the other guy? What did he look like? You said he was pudgy, but how else did he look?
He was pudgy, had shoulder-length brown hair, brown eyes, 5'8", 5'9", and he was wearing a camouflage hoodie.
Okay. Well, did he have the hoodie up?
No.
Okay, so you got a knock on the door after being followed or having people suspiciously drive around your neighborhood for several weeks, right?
Yes.
And this was the day that you were supposed to turn yourself into the jail.
Yes, it was.
And you looked out the window, right?
I did.
And you saw that there was a guy all in black, right?
I didn't say he was all in black.
A black shirt and dicky pants.
He was wearing a black top, that was it.
And a guy wearing a camouflage hoodie, right?
And blue jeans. Yeah.
And you had never seen these guys before, but you decided to answer the door.
I opened the door. We did not have a peephole in the door. It was not uncommon to just open the door. Could have been a neighbor, could have been anybody. I certainly didn't expect that in the middle of the day.
Okay. And they held you up at gunpoint?
Yes, they said, let us in now.
They didn't shoot you?
No, they didn't shoot me.
They didn't shoot your mom?
No, they did not.
In fact, is it fair to say that they killed her with the kitchen knife from her own knife block?
I believe they did, yes.
Okay. And you wrote letters while you were in custody for this offense. Is that correct?
Yes.
You wrote many, many letters to your friends and family members, correct?
Mainly family members, yes.
Okay. Specifically, you wrote letters to Jean?
Yes.
And you wrote letters to your brother, Rob?
Yes.
Okay. And you told them that it wouldn't be unlikely that your fingerprints would be on that knife, correct?
From the standpoint that we all used the knives in the kitchen, I lived in the house, it very well could be on there. I don't know.
Did you tell him any fingerprints that may exist are easily explained as the dumbbells were mine? Did you tell him that?
Yes, I did.
And I regularly use the knife in question to prepare food, correct?
Yes, I did.
And you said you worked out 3 to 4 times per month, and you were living there for 10 months, so it would not be hard to explain that evidence away if it were to appear.
Correct, because I knew what the murder weapons were because I saw the gentleman who used them, absolutely.
Okay, but you never told him anything about the 2 guys who came into the house with guns and bludgeoned your mother to death.
You really don't have that kind of capacity to write from being incarcerated. I told him the key facts.
Oh, okay. You told him the key facts that 2 guys broke into your mother's house?
I don't recall if I told him that or not.
Okay, and in fact, what you actually told him is the timing and substance of this disclosure will all make sense.
Yes, because I knew that I didn't do it, and I would have to sit here in my defense one day, absolutely.
But you never said anything to Janine about these 2 guys who were supposedly out and knew her whereabouts in any of these letters, right?
Janine wasn't reading anything I sent her.
Okay, and what about your brother? You never said, listen, these 2 guys are out, they've got photographs of our family on the phone, and you need to look into this, you need to do something and keep everyone safe.
I had absolutely no confidence that law enforcement would do anything at that point because they took out the warrant for the murder of my mother the same day they found the body and investigated nobody else.
Okay, and you did take, so you said you took your mother's car, right?
Yes.
And you took your mother's phone as well, right?
Yes, I did.
And that doesn't make really a lot of sense. Can you explain why you took your mother's phone?
I took my phone, of course, and I took her phone because of all the calls we had been getting on both my phone and her phone. I assumed that these were the same folks who had been calling us that had killed her. They might have some sort of demands. Janine might call my phone or my mother's phone if these guys made a move on her or the kids, and I wanted to know exactly what was going on. That's why I took both phones.
You've seen the phone records that the state admitted into evidence, didn't you?
Of course.
Okay, both you and you've had the opportunity to review those phone records, right?
Yes.
And there were phone calls made to both your phone and your mother's phone while you were on the run, right?
If I don't recall anybody calling me while I was on my phone anyway.
Okay.
She may have received some text. A lot of those were SMS, not necessarily phone calls.
You never picked up any phone calls to your mother's phone on February 1st, 2019, did you?
No, but if I recall correctly, the calls that came in were people in her contacts, so I had no worries that they were the ones who killed her.
Okay. And you got rid of those phones?
Yes.
You got rid of them before you even cut the ankle monitor off, or around the time that you cut the ankle monitor
Yes,
off?
I don't dispute the data or your expert.
So there was never any intent to turn them over to the police so that they could see whether anyone was after your mom or asking for demands, as you mentioned before?
No, because I took them at their word. Say nothing or this will happen to your family.
Okay. So whose idea was it to turn Mike Jeffcoat down that morning?
It was actually my mother's suggestion. She says, I don't really need Mike to come today. And I said, okay, as long as you're able to drive and get yourself back.
All right.
That was the extent of the conversation.
All right. And, but both you and she texted Mike. Are you aware of that?
Of course.
Okay. you went to Nashville. Is that the first place you went, or did you stop anywhere else along the way?
I believe I stopped in Chattanooga to use the bathroom at a Walmart.
Okay. And you spent those entire 8 months in Nashville, right?
Yes.
All right. Let's be clear, the name you used was Mick Malvo. Where did that name come from?
The alias that I used was from New Orleans. It was a Cajun-sounding name. That's why I picked it.
All right. And you made this driver's license, State's Exhibit 82, yourself, right?
Yeah, I got the template online, yes.
Okay. And you actually had the sleeves that you put driver's licenses in, or at least the kind that you put this in your car when it was collected, right?
I printed it off and believe the business card, plastic laminates, that's what I got.
All right. And even the birth date on this is incorrect.
Yes.
All right. Because it says here that you were born on February 25th of 1980, right?
Correct.
When actually your birthday is February 23rd, 1974.
That's right.
Okay. So you subtracted 6 years on your age because you didn't want to get caught.
I did not want to get found and have my family hurt as a result. I was trying to disappear to protect them.
All right. But you did go on to a dating app and meet women on that, right?
Yes.
Okay. So you didn't have any concern about putting your information out on a dating app, did you?
What information specifically?
Any of it.
Well, I wasn't putting information out there as Richard Merritt.
Okay. All right. And did you speak with a New Orleans accent to Kelly?
No.
All right. And you were never a marketing executive, right?
No, I was not.
That was just something you made up to create this new persona of Mick Malvo.
Yes, that's correct.
All right. And you did not go to LSU.
No.
You were a Georgia fan.
I went to Georgia, yes. I'm a Georgia fan.
You weren't an LSU fan.
No.
And you were not a Saints fan.
Actually, I have been a Saints fan my whole life.
Okay. But you put those stickers on your mother's car as part of this persona of Mick Malvo.
Yes, I did.
Okay. So that was part of the deception. Is that right?
I would call it protection.
All right. And you also put a stolen license plate on your mom's car.
This is true, I did.
All right. So that was part of the lie as well because you didn't want to be found by these monsters.
Absolutely right.
Or the cops.
That would lead to the monsters, absolutely right.
Okay. And you said that you were staying with cousins in Nashville, correct?
I believe that is something I said, yes.
But that's not true either. Is it?
No, it wasn't true.
You didn't have any cousins or family in Nashville?
Not to my knowledge, no.
Okay. And so you didn't really have a place to stay in Nashville?
Not at first, no.
Okay, until you met Kelly.
Correct.
So you were using her for a place to live. Is that right?
I wouldn't go that far, no.
Okay. You told Kelly that you did not have any kids, correct?
That's true.
And you said you had a niece, though, with cerebral palsy.
I did.
And you never said anything about any kind of nephew, right?
No, I did not.
You said that your mom had died of leukemia. Is that a lie that you told?
That's what I told her.
Okay. And you grew your hair and beard out while you were there?
Yes.
And again, that was part of the persona of Mick Malvo because you didn't want to get caught by these alleged monsters, right?
Yes, that's
and
true.
You didn't want to get arrested either.
Well, that would definitely lead to compromising my family, yes.
All right. Mr. Merritt, when you originally stole money from your clients, you stole what, about $500,000, more or less, right?
Yes, correct.
And most of these clients were elderly.
Not most of them, about a third.
About a third, okay. Are you aware that the average age of the clients who are listed as your victims in the indictment is 61.2 years old?
I wasn't specifically targeting the elderly. I believe the law states that 65 and older is elder exploitation.
Okay, most of your victims were in their 60s and 70s. Is that right?
I really don't know the numbers, ma'am.
Okay, and they had been injured in car accidents and other kind of insurance claims. That's kind of the meat of the folks that you were representing and that you stole from. Is that right?
That's correct.
And you would tell them, you would settle their claims with the insurance company and not tell the clients that you had settled, right?
That's what I did.
And so you would take their money from the insurance company and keep it as your own, right?
Well, it would be put back into the firm for the most part, but yes.
Okay. And you also promised to put some money in your escrow account for certain clients, right?
Yes.
And again, you didn't put any of that money in an escrow account.
Pled to all this in January of 2018.
Okay. And you did this because the firm was in trouble.
It was, yes.
Okay.
Actually in trouble.
So, is it fair to say, Mr. Merritt, that when you're in trouble, you lie to try to get out of it?
I don't believe that's fair to say at all.
Okay. Is it fair to say that when your firm was in trouble, you deceived many of your clients, at least the 17 listed in the indictment?
That is correct. I pled to that, yes.
Okay. And is it fair to say that you deceived the people who you worked with and worked for at Betty's Grill as to your name and where you were from and who you were? Is that correct?
That's correct, yes.
Okay, and is it fair to say that you made up an entire story and told a lie to Kelly Richardson because that would be a convenient way for you to get what you needed at that time?
I genuinely cared for Kelly. I didn't need her for a place to stay.
Okay, and yet your entire relationship with her was a lie.
Parts of it, yes.
Okay. So is it fair to say that you have lied and deceived to get out of trouble in the past?
I don't think that's fair to say.
Okay. Okay, so the day of February 1st, 2019, these two guys came in, they killed your mother with her kitchen knife and your weight, right?
Yes, those are my weights.
And they didn't steal anything from the house.
I don't know if they did or not.
Okay, and they didn't break in. You said that you let them in yourself.
No, I'm not aware that they tried to break in before.
Okay, and they had never tried to break in prior to that.
I can't say who tried to break in at any given point.
Okay.
I don't know.
Because nobody, as far as you know, had tried to break into your house prior to that.
I'm not aware of anybody trying to break in, no.
Okay. But they did not leave a scratch on you.
They roughed me up a little bit going down the stairs, but no, they didn't.
Okay. And you were the person who they were after, right?
I'm quite certain that that was their intent when they came there, yes.
Okay. But they just let you go scot-free.
I believe when my mother started to get loud, that's when the gentleman pushed her, and then he finished her off so she wouldn't make any noise. That's what I personally think, and they didn't realize what they got into and they took off. I don't know what their real intentions were. We never got that far.
Okay. They never pulled the triggers of either of those guns.
No, they did not.
Okay. And there was no struggle that caused any furniture to tip over, right?
I don't recall any, no.
Okay. Where did they get that knife from?
I believe they got it from the butcher block in the kitchen.
Okay. I don't have anything further.
No, Judge.
All right, ladies and gentlemen, I'm going to ask you to step into the jury room for just a moment, please. so you can go back to the defense table. Mr. Queen, do you have any other witnesses? Okay. I'm going to bring the jury back out, let you rest, and then I'll ask if the state has any rebuttal evidence. Do you intend to call any rebuttal witnesses?
No, Your Honor.
All right, so I'll let you all rest on the record, and then I'm going to go ahead and excuse the jury. We'll do the charge conference, and then we'll do closings in the morning. Okay. You can bring the jury back out. You all may be seated. Mr. Queen, if you'll call your next witness.
Your Honor, this time the defense rests.
Ms. Pott, any rebuttal evidence from the state?
No, Your Honor.
All right, ladies and gentlemen, the evidence in this case is now closed. The next thing that you will hear will be the instruction of the court or the law that you are to apply to the facts that you've heard during the course of the trial. And then we'll have also the closing arguments by the attorneys. Each side has the option to close for up to 2 hours. So rather than start with the closings this afternoon, I'm going to go ahead and excuse you for the afternoon. There are a few matters that I need to address with the attorneys before we start with the closings and then the charge. So I don't want you all to have to wait for us this afternoon. So when you come in the morning at 9 a.m., we'll have the closing arguments and then the charge from the court, and then you can begin your deliberations in the case, all right? So please remember the instruction that I keep giving you not to talk about the case or allow anyone to talk to you about the case. Please be back at 9 a.m. in the morning, and again, you meet the deputy out in front of 7A at the other end of the hallway, all right? Thank you very much. Have a nice evening. All right, you all may be seated. All right, we're going to go ahead and do the charge conference. So I received the state's request to charge. It's 1 through 9. Is that the entirety of it?
Yes.
Okay. And then, Mr. Queen, I got an initial request to charge and then an amended request, but that's 1 through 9. Is that the entirety of it?
And let's see, Judge, you should have gotten one this morning. I followed a second amendment this morning.
Okay. I don't think I received that one.
Is that it?
All right, well, let's start with the state's request then. State's request number 1. Mr. Queen, I see that you requested the long version of direct and circumstantial evidence. State have any objection to the long version?
I always prefer the short. Maybe look at the long version. Is this his charges? Mm-hmm. Your Honor, Mr. Queen's includes both the short and the long version. Actually,
No,
let me see.
it's just the long version. Unless that's in the amended. No.
Judge, for the record, I usually go with the short version, but in this case, because it is a circumstantial evidence case, I did choose the long version.
Let me look. I'm sorry, I'm just not quite there.
Here.
Okay, thank you. I just can't tell.
Are you asking for any of the parentheticals in the first paragraph?
In the first paragraph, Judge.
I usually read all of them.
I am asking for parentheticals.
Okay. And what about the parentheticals in the other paragraphs? 2 and 1, 2, 3.
Right, one says
4.
indirect, and then there's one which says circumstantial evidence. I am asking for parentheticals, Judge.
Okay. And just so that you all know, it is this court's practice to give a copy of the charge to each of the members of the jury.
You give each one one? Okay.
Yes. Ms. Potts, any objection?
Just that I do always prefer the short, and I would prefer it, but this is, I mean, pattern.
All right, I'll give the long version. Any objection to 2, Mr. Queen?
No objection.
3?
No objection.
And I'm going to give the pattern on all of these. The current pattern. The objection of 4.
No objection.
5, and I will instruct them on the definition of aggravated assault.
That's request number 7, Your Honor.
Right. So in count 4, the heading says aggravated assault, family violence, but there's no language in here to make it specifically a family violence aggravated assault. So
Agreed.
I would just give the pattern on aggravated assault. And then in count 5, seems to be an additional element of age, or the age of the victim.
I believe that goes towards sentencing. I don't know that it's something that the jury needs to be charged on.
All right, then you call it.
If you look at pattern 1.62.00, and it does state, if you find the defendant guilty, you should further specify in your verdict in the place provided whether you do or do not find that, and then it gives the example, the victim was age 65 or older at the time of the event.
That's not your request to charge.
It's not, and it's my mistake.
So as to count 5, when I'm given the instruction about aggravated assault, I would just add that an additional element to the offenses charged in count 5 is that the state must prove that the victim is 65 years of age or older. Is that what you're asking me to do?
Yes, Your Honor. And then give the jury that option on the verdict form.
we'll talk about the verdict form, because I don't think either of you submitted proposed verdict forms, but I do think that count 5 may require some additional instruction. Okay, and state's request 3. And 4 are not the current pattern, so I think I did say that before, but I will be given the pattern. Yes. The same with state's request 5, I'll give the current pattern. And I think state's request number 6 is consistent with the current pattern. So any objection to 6?
Yes.
Okay.
We would have said, it's in the causation case.
I don't think that there's any. I don't think this is talking about causation. This is describing what's required for the felony to be considered a cause of the homicide. So this is in the pattern. Giving further instruction about felony murder.
I'm not disagreeing with you, but the evidence in this case, where causation, a knife to the face, a dumbbell to the head, it's really a causation case, but...
I'm sorry, I didn't understand what you said.
I'm just saying, causation in this case is not an issue. The language, it may be illuminated for some people, but I think it's unnecessary in a causation case, given the level of violence with both instrumentalities. So I'm just placing an objection on the record.
I understand. I'm going to give 6. All right. As to 7, what I usually do is to split the counts up so that there will be a section that says count 4 aggravated assault. And this is with an offensive weapon. Okay. So for count 4, I would read for aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. Any objection to that as to count 4?
No objection.
And I would read essentially the same thing as to count 5, but indicate that there is the additional element that the state must prove the victim in the case was 65 years of age or older. Any objection to that?
No objection.
No, you're.
Okay. And state's request 8 is still part of the pattern, or is still the pattern. Any objection to 8?
No objection.
9.
I assume subsection A on.
Yes, Your Honor, that's what I'd ask for.
Yes. So, any objection to 9?
In that form, no, Your Honor.
All right, let's go to the defendant's request to charge. So I'm looking at the amended request, and then we'll look at the second amended, because I think the amended one includes everything that was requested in the original.
I think I only added like 1 or 2 to the original, Judge.
Okay.
Your Honor, may I ask what date that one was?
May 16th?
Okay. Okay. And then the amended, the second amended is May 23rd, is that right?
Right.
Okay, all right.
Okay. Any objection to 1 from the state?
No, Your Honor.
2? I don't think we have any of the parentheticals.
No deposition, no stipulations, correct, Your Honor. No judicial notice.
That's correct.
We talked about direct and circumstantial evidence already. Any objection to 4?
Is that the expert witness?
Yes.
No objection.
Are you withdrawing 5?
I'll draw 5.
Any objection to 6?
No objection.
All right, I'll take out any reference to party to a crime. Any objection to 7?
Let's see. This is pattern. This is pattern. No objection.
Okay. What about the parentheticals? Which ones of those are you asking me to give? I think
On the article allege.
Okay, so not at the scene.
Correct.
Okay. And on the weapon.
Correct.
All right. Any objection to 8?
No.
Or you were drawing 9?
Nope.
What good character testimony do we have?
I think we have character of the defendant for a particular trait, more specifically nonviolence.
And who testified about that?
His wife did, then she tried to qualify it by telling her story. And then the defendant did.
So, who do we have who offered an opinion or some indication of reputation or specific instances of conduct?
We heard from Ms. Manacosi evidence of the character of the defendant for a particular trait, specifically nonviolence.
That's not my recollection of her testimony.
And then she qualified it by saying there was some incident.
When did she testify that he had a particular character trait of nonviolence?
That was in the midst of the cross before she backtracked from him and told the story about him pushing.
And so what you're alleging that's her opinion in reference to the second set of parentheticals. So
Yes.
What was the form of this testimony?
Opinion.
Any objection from the state?
I mean, I don't recall her saying that he had a reputation one way or the other. And she specifically gave an instance of conduct. You know what? I'm not going to object.
Okay. All right. Any objection to defendant's request 10?
I don't have, oh, I'm sorry, is that the one?
The second amendment is this.
That's the second amendment. It's sympathy.
No.
Judge, I wasn't sure if that was in your standard package or not, so that's why I asked for it.
It is, but I don't usually give the parentheticals in the second paragraph unless there's some specific evidence of them, and I don't think we have that in this case.
That's fine, Judge.
Okay. And I noticed that neither one of you asked for presumption of innocence, burden of proof. I do generally give that. I will instruct them on their responsibilities as jurors about the indictment and the issue and plea of not guilty. And I will instruct them on credibility of witnesses. Nobody's requesting impeachment, right? I didn't see that in any of the charges. Definition of crime, anybody requesting that? I usually give that.
You usually get that, I assume.
Yes, I mean, nobody requested it, so,
Judge, and just for future reference,
mm-hmm.
do you want us to submit everything and then
Yes.
sort it out?
Yes.
Or
even if
something
all
that's-
you do is a checklist.
Okay.
It can be 1 through 20, and you just put the names. You don't necessarily have to give me the pages. You could just give me the numbers.
Okay. 'Cause everybody's different, and okay.
So I give definition of crime and intent. No presumption of criminal intent. Is anybody requesting
I
that?
assume you did that.
I'm just trying to make sure we're all on the same page. That nobody says, well, I assumed you were going to give it, but you didn't give it.
Right.
Okay. Presumptions and inferences
Please give.
and venue.
Please give.
Okay. And that's the extent of the standard pattern that I usually give. Is there anything else that you can think of that is not in the request to charge that you want me to give?
Not from the state, Your Honor.
No, Your Honor.
Okay. So I will send a draft copy of the charge to you by email this afternoon so you all can look at it overnight, and then in the morning we'll address whether or not you have anything additional that you want me to include or anything that needs to be corrected. And I'll also send you a proposed verdict form to look at. Okay?
Thank you.
All right. Anything else before we recess?
No, Your Honor.
And we did find out that the smell that we smelled this morning was the fan that they installed so that the air would work and it wouldn't be warm in here. It blew out. So that's what that smell was. So they're coming at 5 today to put in a new fan, and hopefully that one will last us until we can finish up with the case. Because right now the air's not working in here. Okay. All right. See you all at 9 in the morning.
Good.